16 appointee. Thereafter, my lord, the fate lordship knows nothing to be clarified. But given the upper primary appointment letter at that point, appointment letter after recommendation. That is in December 2024. I paid for some time because of the matter pending for the Supreme Court.
But in my court, it comes as per presentation date.
Presentation of
As per date of presentation, it comes. You file, serve notice, come back.
Nowadays, my lordship.
I know, because the matters are not being taken up on a particular day when it comes.
Previously, it was being taken
Yes,
on that
because
day.
of the pressure.
Only I am taking leave of your lordship.
You file it, Mr. Bhattacharya, you file it, then mention, ask your junior to mention, I will accommodate. There are other matters.
Which order is covering the issue?
Yes, I will consider. You plus file it, give a date, and let the matter come. And if it is not taken up, ask your junior to remind me.
May I be permitted to mention one matter, Lordship? This is urgencies that.
It's not the mentioning date. Mention on Monday.
True, Lordship. But the urgencies, Lordship, is very.
What is the urgency?
The urgency is that the item number 2096 of monthly list. Lordship, the petitioner is a lady teacher who has a scheduled date for delivery of in IVF process on 13th of June. Lordship, that date has missed, Lordship, due to some medical complication. Lordship, the transfer application I prepared, Lordship, unless the transfer application is hard out and an order is
passed. I am not updating any transfer matter.
Also true, but the medical emergency.
Sorry, I have not upgrading any transfer matter.
So my exceptional circumstances.
Yes, please. Sorry. Yes, please.
My lord, may I, my lord, seek one leave, my lord?
No,
My lord has fixed one matter, my lord, on fast, my lord. My lord, kindly here for a minute, my lord.
Mentioning, please.
My lord, kindly, my lord.
Today is not mentioning that. Please don't disturb this court.
My lord has fixed this similar matter on fast, my lord. If
mention on Monday, NIOS matter?
No, my lord, NIOS not. This is, my lord, age relaxation in second SLST, my lord.
File it.
My lord, fast,
no leave,
fast will not come, my lord.
No
that
leave,
is,
file it.
My lord,
it
fast.
Comes under, as per presentation.
My lord, 72 hours is
leave refused.
My lord,
leave refused.
My lord has
file
the similar matter on fast, my lord. That is Tuesday, my lord.
Item number 1.
I beg to appear for the petitioner in this matter.
Yes.
But this is for correction, my lord.
কি কারেকশনের জন্য এসেছে বলো তো? ম্যাটার না? Yes, it has come from the department for correction. Yes, matter has come up in the list for correction of the order dated 28 April 2025. Inadvertently, while transcribing the order, year at the heading, year of the writ petition was printed as 2025 instead of 2023. Stop. Year of the writ petition shall be read as 2023. Stop. The department is directed to incorporate necessary correction. Next paragraph. Let this order forms part of the order dated 28 April 2025. Item number 2.
In this matter, I am appearing for the state matter. Directed to PPO.
Just a minute, let me go through my own. Who is for the petitioner? Whether the pension payment order has been issued? Just a minute. Yes, pension payment order has already been issued. Issued. In terms of order dated 20th May 2025. A report is filed dated 11th June 2025 on behalf of Director of Pension, Provident Fund and Group Insurance. Being respondent number 4. Enclosing copy of pension payment order dated 30th May 2025 and same are taken on record. Stop. On perusal of the report it appears pension payment order was issued on 30th May 2025 for releasing family pension in favor of the petitioner. Stop. Next paragraph. In view of issuance of pension payment order, grievance of the petitioner stands redressed. Stop. Writ petition stands disposed of, urgent xerox certificate. Next.
Item number 3.
And for the same.
Is my supplementary affidavit. My lord, last occasion your lordship.
Just a minute. Yes, supplementary list.
My lord,
Supplementary affidavit.
my lord, supplementary affidavit. My lord, I have annexed here. My lord, I have handed over. My lord,
Yes.
kindly come to page 4 of supplementary affidavit annexure. P5.
But this is a breakup score. Score is not a list of trained candidates.
My lord,
What is the heading? Come to page 5.
my lord,
Read the heading, page 5 of supplementary affidavit. Breakup,
panel
yes,
for
please
the
read it.
recruitment process of here our name, beside our name, it has been marked that untrained.
How it has been marked as untrained?
Sudha,
How it is marked as untrained? Show me.
my lord, there is no any trading scores.
Because you did not, you show me that you appeared as a trained candidate.
My lord, I have,
You show
appeared-
me by submitting
I am
application in 2016 selection process, you appeared as trained candidate.
my lord,
Show
I
me.
appeared as a trained candidate. My lord,
Subsequently, certificate was issued.
similar matter, my lord Justice Amrita Sinha has been pleased to pass.
No, I don't. I want to hear from you. Don't rely upon similar. I have passed many orders.
My lord, my lord,
But this list is to be changed by showing your marks against training, where question arises after since you appeared as untrained candidate. Show me your application.
Your lordship has rightly pointed out one document, my lord, if is shown before your lordship that at the time of
Subsequently, you are sanctioned
application-
academic scale of pay. Subsequently, you are considered as trained candidate.
Right.
That's why, in similar matters, this court has passed several orders directing to treat the petitioner as trained candidate.
Right.
But list is to be changed. Then the very record of this selection process will be changed.
my lord,
Then next date you will pray
Is
that
there-
since list has been changed and training marks for training is shown, then the panel is to be changed.
that is
That
not
I cannot allow.
No, my-
You have to show me that you appear in the selection process as trained candidate showing your training qualification.
my lord, much after the selection process, my lord, kindly come to page 4. for it.
Yes.
They have published on 28th of November 2022.
This is a page 5.
It is hereby notified to all concerned that in compliance with the solemn order of the Honorable Justice Abhijit Gangopadhyay passed on 23rd 9th 2022 in the number so and so, can number so and so, the West Bengal Board of Primary Education is uploading the breakup score of TET 2014 qualified impanel candidate against 42,949 and 16,500 vacancies in 2016 and 2020. List enclosed and
Today, if I direct that you change the breakup of marks,
no,
that would be an improper
my
direction.
lord, I am not praying for.
Sorry.
I am praying only for in place of score. My should be trained candidate.
How? Why?
My lord, they
If
have
you applied
considered-
for trained candidate as trained candidate,
Lord,
show me any document.
my lord, allow me one day
Otherwise,
time.
yes.
Allow me one day time.
No, sorry, no further
My
permission.
lord, kindly consider. I
Sure.
talk to my lord, kindly consider. My lord, I am led by
In
Mr.
terms of
Islam.
the order dated
My lord,
20th May,
My lord, I am led by Mr. Islam.
20th May 2025, the supplementary affidavit is filed, enclosing
No.
a list, and same is taken on enclosing list of candidates relating to recruitment process of 2016. For the post of primary teachers. And same is taken on record. Next paragraph. contention of the petitioners is by publishing this list showing breakup score of panel for the recruitment process of 2016. Petitioners were shown as untrained candidate. It is submitted that they were appointed on being selected in 2016 selection process conducted by West Bengal Board of Primary Education, and appointments were made in the month of February 2017. Petitioners subsequently obtained DLED qualification and certificates were issued on 23rd August 2017. In consideration of their DLED qualification, petitioners were sanctioned A category scale of pay. And A category scale of pay. As such, petitioners need to be treated as trained candidate. Next paragraph. Such contention raised on behalf of the petitioners is denied by the learned advocate representing, is disputed by the learned advocate representing West Bengal Board of Primary Education. Since it is submitted, issue involved in this writ petition is not treating the writ petitioners as trained candidates, rather petitioners are claiming allotment of marks against training qualification in connection with 2016 selection process. Next paragraph. In terms of notification dated 28 November 2022, a list was published pursuant to order dated 23rd September 2022, passed in writ petition being WPA 7907 of 2022 by the board. Thereby uploading breakup scores of TET 2014 qualified impanel candidates against 42,949 and 16,500 vacancies in 2016 and 2020 selection process, 2016 and 2020 selection process. On perusal of the relevant part of the list which is annexed to the supplementary affidavit, it appears that against the column quote unquote training score in connection in respect of name of the petitioner, in names of the petitioner, space was kept blank. So precisely prayer is made by keeping by not showing training score against names of the petitioners in the list. They are being treated as untrained candidate. Next paragraph. As it appears from page 5 of the supplementary affidavit, it is a list of candidates for disclosure of
Breakup of scores.
breakup scores in connection with 2016 and 2020 selection processes. And prayer of the petitioners cannot be acceded to, since it is admitted position that they appeared in the selection in the sets, or they participated in 2016 selection process, not as trained candidates. Therefore, today, if court allows this writ petition giving direction upon the concerned authority of the board to disclose marks of the petitioner against training qualification, that would alter the panel position, which ought not to be permitted at this stage. Stop. Next paragraph. But it needs to be recorded herein, since petitioners obtained training qualifications subsequently, by issuing certificates on 23rd August 2017 and based on issuing training qualification on 23rd August 2017, based on which A category scale of pay was granted to them. Irrespective of disclosure of breakup of marks relating to their participation in 2016 selection process, they are required to be treated as trained candidates since in similar other cases this court has passed order directing the concerned authority of the board to treat them as trained candidates. Stop. However, changing list, thereby showing marks against training qualification of the petitioners, is found to be impermissible, since at the material point of time they participated as trained candidates.
As untrained candidate.
Untrained candidates. Next paragraph. With the above observation, writ petition stands disposed of. Urgent xerox certificate. Next matter. Yes. Next.
Item number 4.
তোমারই মেন বলার
Yes, who is for the petitioner? Yes.
Notional benefit, my lord. The petitioner, my lord, participated in 2014, my lord. Thereafter, he was not qualified due to, my lord, 6 marks. Later,
I have passed order 2 days back
Yes, your
in some
lordship.
other matters
Yes.
where I directed that to grant notional benefits from February 2017. From February 2017, though petitioners were appointed in 2021 October.
20.
So where are those orders?
This is not like this.
Sudipto Dasgupta.
It is not like that petition.
Oh.
I appeared
Mr.
there.
Sudipto Dasgupta appeared
I
in those
appeared, my lord.
matters.
I also appeared.
My lord, only difference in this
Yes.
matter, my lord, is that the petitioner, এখানেও দুবার read petition ছিল. My lord, I'm sorry, my lord. I'm tendering my apology. My lord, only difference is that petitioner, those petitioners was participate in 2016 selection process, and they get appointment under 2016 selection process, and the petitioner participate in 2020 selection process. He got appointment under 2020 selection.
Difference is that those petitioners were participated in 2016 selection process.
Yes,
And here 2020 selection.
2020 selection process.
Now, in 2020 selection process, whether the petitioners got the benefit of 6 marks
Yes, after getting a petition, similar fact, my lord, of
when petitioners were appointed.
my lord,
Petitioner was appointed in this matter.
petitioner is appointed, my lord, 2022. Yes, your lordship, 2022.
28 April
Page
20.
41. 20. My lord, joining date is 28 and 28 March 2022. Page number 42, my lord.
Page 42, joined the post of so on 26 March 2022.
26.
Handwritten at the bottom,
Yes, it is put on 26.
28 March 2022.
No, no,
28.
no, no,
Yes, yes, your lordship. 26, my lord, endorsements is not 28. That's why, my lord, I am.
On 26 March 2022.
Yes, your lordship. Joint date is 26 March 2022.
Now, yes, you are correct. That selection process is different.
My lord, not
That
only
this is
selection
connection
process.
connection with 2016 selection process, and this is in connection with 2020 selection
My lord,
process.
my lord,
But
may
why the principle will not apply?
I just coming, my lord. Just I'm coming, my lord. Just, my lord, before that, my lord, I should narrate your lordship, my lord, the facts, being an officer of the court. My lord, 2016 selection process, my lord, sorry, my lord. 2014 TET was held, 2015, result declared 2016. Thereafter, 2016 selection process. My lord, in 2014 TET, my lord, there was an allegation that 6 questions were wrong. My lord, petition was filed. My lord, the single bench directed to give 6 marks to the petitioners. My lord, against that order, my lord, some contempt was pending. My lord, since board was not awarded 6 marks, contempt are pending. My lord, in contempt petition, my lord, given 6 marks, appointments were given. After a my lord, gap of my lord, 20 or 2021, the appointments were given on the basis of 6 marks in the TET 2014 and connection with the selection process of 2016. My lord, here it is a different case.
How?
Here, petitioner did not approach before the learned single judge for paying of 6 marks. Or, I say, my lord, they didn't get any order from the learned single judge to award of 6 marks. Thereafter, 2020 selection process declared. 23rd December 2020, my lord, the employment notification issued. As soon as the employment notification issued, my lord, a group of candidates rushed before this court and my lord, paying for my lord, that since my lord, paying for 6 marks. Why? Their contention was, unless we are given a 6 marks or the dispute is resolved, this selection process should be stalled, and unless we are awarded 6 marks, we cannot participate in 2020 selection process. This was the contention. My lord, when the learned single judge, the Honorable Justice Rajashree Bharadwaj was, my lord, hearing the matter, my lord, we considered, the board considered that those who have approached before this honorable court, let them file offline application. We'll consider if after consideration, if we found that they are required, after giving 6 marks, they will be qualified. They will be allowed to participate in 2020 selection process. The order was passed. The notification was issued. Ultimately, it was found 738 candidates are entitled to awarding of 6 marks. 6 marks was awarded 738 candidates. They qualified in the 2014 TET. And prayer was to allow me in 2020 selection process in those writ petitions. On the basis of their prayer, they allowed in the 2020 selection process, and they succeeded. The recommendation was made. Appointment
Along with other regular candidates.
absolutely of 2020 selection process.
What is the delay?
My lord, there is
Because you have to keep this aspect in mind, that you are praying for notional benefits. What is the concept? That if those 6 marks would have been allotted in right time, then you would have been appointed earlier,
And as of today, your
not
lordship,
belatedly.
my lord, yes, sir.
Wait.
Sorry.
Belated.
Sorry.
Now, in case of 2016 selection process, matter was ultimately resolved in 2020-21 by giving direction that this 6 marks is to be added, or in 2017-18 when it was decided by Justice Manta.
Pratibha Mondal decided 2018.
3rd October 2018.
3rd October
Of
2018.
2018.
Right.
Now they are after contempt. Ultimately in
Supreme Court
2021, it was that those candidates in connection with 20 selection process were awarded 6 marks. On awarding 6 marks, they came within the zone of consideration. They were given appointment. But regular candidates who did not require awarding of 6 marks in connection with 2016 selection process, they were appointed in 2017 in connection with 2016 selection process. So therefore, the reasoning is this: had there been awarding of 6 marks in appropriate time, in that event, those petitioners in connection with 2016 selection process would have been appointed in 2017. But in the case at which this court is considering, that is not in connection with 2016 selection process, that is in connection with 2020 selection process. Now, in 2020 selection process, awarding of marks was just subsequent to initiation of selection process by the dint of order passed by Justice Rajashree Bharadwaj. And these marks were awarded. They were, please don't nod your head in this fashion when you are appearing before this court.
Yes, sir.
You have to hear it and then you have to reply.
Yes, sir.
You please take your seat. Yes. You should know how to address this court. Yes. Now, then you will reply. You will get chance to reply. Then in 2018, in connection with 2020 selection process, these candidates were not permitted. Then they filed a writ petition. Justice Bharadwaj directed, no, they are to be given 6 marks if they are coming within the zone of consideration. On awarding 6 marks, it was found that yes, they are the eligible candidates to participate, and they were appointed along with regular candidates of 2020. Then where is the delay
My lord,
in giving appointment?
my lord, delay is, my lord, this petitioner approached before the honorable court in 2018 also. My lord, what happened? My lord, there is
No,
several...
you tell me that in 2020 selection process, when regular appointees were appointed.
2021. And my
Yes.
lord, there is no order of Justice Bharadwaj. Justice Bharadwaj order is that you accept the offline application. There is no order for giving 6 marks. It is on volition of the board. initially what they did, they keep 738 seat vacant, and they proceed with the selection process. Later on, when the notification in 2022 given, appointment is given February 2021, and at that point of time they did not take steps because there is no order. Subsequently, in the year December 2021, they published one notification by their own volition that we will fill up the 738. There was-
What is the cutoff date you are saying that when you were not permitted to participate?
I did not participate in 2016 selection process also.
16 selection process is not under consideration here. In 2020 selection process,
February 2021.
February
First
2021 is the
re-
date. Is a February 2021 when other candidates were appointed.
Yes, in connection with the 2020 selection process.
So your contention is this: if these 6 marks were awarded at the right point of time, you were also appointed in February
February
2021.
2021, my lord, kindly
Yes,
let
yes.
consider, my lord, one thing.
Yes,
My lord, my contention is that
I am not nodding my head when I am hearing you.
I'm
Yes.
tendering my apology, my lord. My lord, my contention is that, my lord, the petitioner is a trained candidate at that point of time also. If the board, my lord, there is no order for giving 6 marks, it is own volition of the board. They took decision that they will give 6 marks to those candidates. My lord, my contention is that if the board, it is wrong on the part of the board, if they took the decision in the year 2016 when the other candidate got the appointment.
16 is not under consideration. You did not appear in 16. It was not. Forget about 16. Restrict your submission in connection with 2020 selection process. In 2020 selection process, regular appointees without awarding 6 marks, they were appointed in February 2021.
21.
Now, when the last appointment was made in connection with 2020 selection process without awarding 6 marks,
February 2021.
that was the last date of appointment.
Yes, your lord.
So why they will not get
No, no, I'll tell you, Lord.
notional benefits from
I'm-
February
I'm-
2021?
I'm answering you, Lord. No, एक minute, brother. My lord, I'm answering. My lord, 2020 selection process, my lord, because all the, my lord, the notifications were not annexed.
Now you tell me one thing.
I'm just
No, simple thing. Today I am not concerned. Please answer the query of this court.
I'm
If
answering.
Petitioners,
Straight away I'm answering.
if petitioners were given these 6 marks at the right time, then petitioner would not be appointed, would not have been appointed in February 2021.
My lord, I'm just
Lord,
Please say yes or
I'm
no.
answering, my lord, I'm answering, my lord. My lord, that is why, my lord, when the order was passed by Honorable Justice Bharadwaj, my lord, the notification, a particular notification was published by the board on February 2021. My lord, if I am not wrong, 14th February 2021.
Yes.
That notification was questioned. The Honorable Single Judge was pleased to stay the operation of this notification. It went to the division bench. Your Lordship, my lord, sitting with the division bench, my lord, modified that order. My lord, allowed us to permit us to, my lord, give appointment and conclude the, my lord, the 2020 selection process. In that particular notification, my lord, those, my lord, the candidate who were awarded 6 marks or would be about to awarding of 6 marks, where, my lord, specifically, my lord, was given, my lord, 738 candidates were separately, my lord. In the particular notification, it was, my lord, that first, my lord, my lord, the exact, my lord, the number I cannot remember right now, my lord, that 12,000 and odd will be given appointment, 438 and 487 and 738 candidate will be thereafter. That notification, it was specifically mentioned and
Now
issued by
these candidates are coming under 738 head.
738 head. And after, my lord, giving, all 738 were given appointment.
Why 738 were directed not to be given appointment?
I'm just
Because the issue was pending.
issue was
Whether this 6 marks benefit is to be given to them or not.
even
When it was decided no, then ultimately you have also submitted that board considered before Justice Bharadwaj. No, we are going to grant them the benefit of 6 months.
Yes. I'm
And which permitted them to come within the zone of consideration and they were appointed.
yes.
Now, if this benefit was given at the very moment, at the
Malad-
right point of time,
Malad, in the meantime, there was a stay of this honorable court. But after that stay, Malad, if I know not place the Malad the
if
notification,
stay was there, stay merges with the final order.
Malad stay final. Malad,
Stay merges with the, why stay? Because not to appoint this not to fill up this 738
no,
vacancy.
entire thing was
Not
stay.
to fill up this 738 vacancy.
Entire
So
selection was
ultimately,
stay.
when you have awarded these 6 marks,
But as soon as it was awarded, Malad, we give an appointment. After scrutiny, verification, everything.
Just in this similar circumstance, coordinated by
Malad, let him submit, Malad. Whether I am forgotten or not, Malad, it is not his concern, Malad.
In the stay was not the issue of the 738.
My
For the
client
purpose
speaking
of
here.
that non-publication of the panel. In that score, the single bench stay was there, and it is ultimate went up to the division bench, and division bench ultimate because in that matter they says
All notification are
due
not
to
annexed to the
cyber
division.
hacking they compelled to withdraw the panel. So that's the subject matter. That subject matter, and 730 they give 6 marks, 738 candidates without having any court order. So with any court order regarding 738, give 6 marks to the 738 particular 738 candidate. Not a singular.
Malad, what was the prayer of my learned friend Malad in the writ petition before Justice Bharodar? Let him Malad place the Malad writ petition. He has not annexed the writ petition. He has annexed the notification also.
Third petition. Third
রাস্তা রোড ভালো পাশে পাহাড় পাথর এসে পকি বসলে সেদিকে
এটা তিনটে ফেজে অ্যাপয়েন্টমেন্ট হয়েছে, জুলাই, ডিসেম্বর, ফেব্রুয়ারি। আমি জানি না কারণ
ছিল অমৃতা সিনহার ওটা 2020 সিলেকশন। দেখুন
016 of 24. 01016 actually.
issue is decided already.
Yes. Ma'am. It is already decided.
You have not preferred any appeal against this order. What remains for consideration, Mr. Vishwas? Unnecessary, you are making submission and court is hearing. It's no more res integra. Today, if I pass a different order, then I have
let
to-
me just now
Yes,
handed
yes,
over.
go through. It's a very short order.
Let your lordship can take it up tomorrow.
No. I have heard you for such a long time, both of you. And one thing is correctly observed by Justice Sinha, that they lost the opportunity in 2016.
No, I'm not quarrel with this, Malad. Malad, the prayer of the petitioner is otherwise. I'm just one thing.
No, our court will not grant any prayer, only notional benefits from February 2021.
Malad, all the candidates were not given appointment 2020, February 2021. Immediately, Malad, one or two appointments.
You decided that appointments were given from February 2021 in your presence. You have not preferred appeal 21st of August 2024 order.
একটাই তো ভুল বলে
পুরীর একটাই আর বাকিগুলো 16 ছিল একটাই
Malad, the status, whether the status of the Malad writ petitioner and the order cited before your lordship is not similar, or I do not know, my lord. একটু স্বার্থকে পেয়ে যাবো।
Yes, you have rightly pointed out that prayer is to approve the appointment of the petitioner from 2017 and grant notional benefits. Court will disallow this. Court will direct only to grant benefits from February 2021.
Malad,
Yes.
that is
Yes, court can mold. If prayer is made that give me benefit from 2010, court, considering the nature of or the nature of issue involved in this writ petition, court can grant benefits from subsequent date. Yes, prayer might not have been properly couched, but the issue is decided, Mr. Chattopadhyay.
issue because yesterday night I got it.
Issue is decided and rightly decided. In 2016, they missed the opportunity since due to non-awarding of 6 marks.
Malad, probably not February, it would be the July. Because Malad, the appointment was given Malad
Sure.
July 2020, Malad. 2021, Malad.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner appeared in 2014 date, but was not qualified.
Yeah, 16 থেকে আমাদের 16 হিসেবে আসবে 16 থেকে পাবে
Which debarred the petitioner from participating in 2016 selection process.
Because it would be because my learned friend is rightly said the next there is a correction order because I came with the all order it will be July 20.
I Malad,
So he is submitting this.
all on a sudden Malad, a copy of the order Malad, I cannot Malad.
Yes, Malad. Yeah, I got it yesterday.
But I learned Malad, I never mislead the court, and Malad, I never Malad.
Previously, it was February 2021.
Yes, yes.
Because of
July 2022.
Yes. Subsequently, this is the next order. Because of that, Malad, I came with all order. Because of that, it is a corrected one.
Because the order of there was a stay, that is why we could not make appointment.
Just in second line.
And thereafter election, embargo was there.
Justice Somen তারপরে ই করে দিল
তারপরে embargo ছিল, ইলেকশনের embargo.
Second paragraph it will see.
এইসব মামলা দেখলে না তোরা
Second line of the last paragraph page 2.
দেখি ওই কারেকশনের অর্ডারটা
In my fact, sorry.
ইনক্রিমেন্ট বাড়বে এদিকে 3 মাস আর এদিকে 4 মাস 7 মাস
জুলাই
হ্যাঁ আমি তো 2 মাস এদিকে বলছি তো আগস্ট সেপ্টেম্বর অক্টোবর নভেম্বর ডিসেম্বর না ওটা তো 28 মার্চে জয়েন করেছে জানুয়ারি ফেব্রুয়ারি মার্চের 28 তারিখ 2.5 মাস আর ওদিকে হচ্ছে তোমার আগস্ট সেপ্টেম্বর অক্টোবর নভেম্বর ডিসেম্বর মার্চ আর 7.5 মাসের
Just a minute. Mr. Bishwas, when
Hello.
the last candidate was appointed in connection with 2020 selection process?
December, February, March also.
2022.
2020, even a March, face candidate.
Last candidate from the panel.
I
When
tell
appeared?
your lordship.
Tell me when the last candidate.
Exact date, because the different district, that is why I cannot tell you the exact date. I can tell you the month or even March, April, it was given appointment face candidate. Even those who are not awarded
March, April of 2022.
2022.
July also.
July also,
Because of that, those candidates who got 738.
Not only 738, all
Some
the
of the candidates.
738 candidate, the fresh candidate was also considered because of the rules.
So let the appointment benefits be given from July 2022.
That I leave it to your lordship, but
Kindly take the last paragraph of second page. It would be February 2022 for my case, March 2022.
No, that is in connection with giving incremental benefits.
Yeah.
Incremental benefits from July 2020.
No. It would be the February 2021 to, in my case, March 2022. Kindly turn page number 42 of my writ petition. Because I joined in the post March 2022 because there are 3 slabs.
And because of the embargo of the election, we could not make appointment February. An order of the court, we could not give appointment, my lord.
Yes, হ্যাঁ কি বলছিল Subsequently, 2020 selection process was initiated. Subsequently, selection process of 2020 was initiated by the respondent authorities, where also petitioner at the beginning was not considered as eligible candidate to be considered for appointment in the post of primary teacher. Stop. Issue was considered by this and due to intervention of court. Now, issue was taken into consideration. Issue was taken into consideration, and due to intervention of court, petitioner was awarded 6 marks in TET 2014 in connection with participation in TET 2014 that made the petitioner eligible to be considered for appointment in the post of primary teacher in connection with 2020 selection process. Next part. In the process of awarding 6 marks, which brought the petitioner into zone of consideration, delay occurred in appointing the petitioner in connection with 2020 selection process. As a result whereof, petitioner was appointed in March 2020. So, according to the petitioner, if petitioner would have been appointed along with other regular candidates or along with other candidates who at the beginning of 2020 selection process was found, who were found eligible or were adjudged as eligible, then petitioner could have been appointed along with those candidates. Stop. Delay in appointing petitioner caused denial of, next paragraph, delay in appointing petitioner caused denial of service benefits which were enjoyed by similarly circumstanced other candidates who were appointed in time. Next paragraph. Mr. Bishwas, learned advocate representing West Bengal Board of Primary Education, and Mr. Chatterjee, learned additional government pleader, have jointly opposed the prayer made on behalf of the petitioner. And attention has been drawn to the prayer couched in this writ petition, wherein mandamus is sought for to grant approval in favor of the petitioner with effect from 2017 onwards, and release of benefits thereof, release of service benefits thereof. Stop. It is also submitted on behalf of board due to pendency of the issue before the court. Timely steps could not be taken along with other candidates where there was no dispute relating to awarding 6 marks. Next paragraph. It appears that due to non-awarding of 6 marks at right time, petitioner left the petitioner was denied opportunity to be considered in 2016 selection process first, and subsequently in 2020 selection process there was delay in giving appointment. Had there been awarding of 6 marks at the right time, petitioner would have been benefited from giving appointment earlier, which could make the petitioner entitled to receive benefits from earlier date. Next paragraph. In view of aforesaid situation, concerned authorities of board and district primary school council or concerned respondent authorities are directed to grant notional benefits to the petitioner from the date when yes, Mr. Vishwas, from which date? You tell me.
Right now, I really, I cannot ascertain you. Right now, if the proposition of this order, I'm not with the I was argued, that he is paying for 17. That is why, but the
From the
right
date when other candidates were appointed in connection with 2020 selection process without subsequently awarding 6 marks. Stop. It is stop. Respondent authorities are directed to. Now, chairman district primary school council is directed to. Chairman concerned district primary school council is directed to fix the pay of the petitioner. Reckoning grant of notional benefits from an appropriate date in terms of aforesaid direction and pay is to be fixed accordingly and consequential benefits to be allowed. Stop. However, it is clarified that petitioner is not entitled to get actual service benefits during the aforesaid period. Fixation of date from which notional benefit is to be granted by the petitioner. Notional benefit is to be granted to the petitioner shall be made by the chairman district primary school council by passing an appropriate order within a period of 8 weeks from the date of communication of this order.
8 weeks.
Taking note of appointment of other candidates in the district in connection with 2020 selection process without belated awarding of 20 marks. So, next paragraph, writ petition stands disposed of urgent xerox certificate.
Election embargo chilo. তারপরে কোর্টের অর্ডার ছিল।
Second page, para 3. Specifically stated,
No, I have passed order in my own way. Let the chairman pass an order because in Mr. Dasgupta's order also, case also, I have seen that chairman district primary school council Bankura has passed an order.
Chairman is the appropriate authority.
So the last candidate in the district from 2020 selection process without awarding, without belated awarding of 6 marks would be the date to be reckoned for awarding.
That would be the exact principle.
For awarding notional benefits.
Absolutely right, your lordship. That would be the exact.
Because problem is you may have other cases.
I mean,
District to district, that will vary.
That is why, I could not say that date. Exactly.
Please call the next matter. Enough is enough. Yes.
Item number 5.
You will find the last date in Bankura is 1, in Purbo Medinipur is 1. So let it be decided. Let it be decided by the chairman.
in 2020 election.
Yes, what is the matter about?
For the clarification of the court, in 16 election process, that was the case, but in the 2020 election process, both conducted. So that.
What is the matter about?
But this matter category, what a regular matter. This is not 2009 election process.
B.Ed.
Yeah,
Waliar Rahman case.
Honorable Collier Rahman is also arrested and minor fraud. This is regular.
তোমাদের বলার
ডেট অফ অ্যাপয়েন্টমেন্টে বিএড ছিল
ডেট অফ অ্যাপয়েন্টমেন্ট পিএড ছিল ডেট অফ জয়েনিং কিভাবে দেবো পিএড 2020 সালে
না না এই 2016 সালে যারা বিএড হিসেবে চাইতে যায়
এসো শোনো, তুমি না এটা ট্রান্সক্রাইব করতে গিয়ে বারবার ভুল করছো। তুমি তো একটু ইয়ে দেবে, একটু মন দেবে এটা ট্রান্সক্রাইব করতে গিয়ে বারবার কারেকশন করো। 3 weeks কমিশনার অফ স্কুল
Malad, this is not the similar matter. This is not the similar matter. Your Lordship, kindly see the page 64.
Page 64.
Yes.
So why you are not making submission?
Malad, since your Lordship, Malad, 2016
Yes, why you are not making submission?
Malad, your Lordship was Malad, that is why I.
Yes.
Malad, 2016 selection process, all untrained candidates were undergone DLED through NIOS. Malad, he has
Not a
chosen
B.Ed
not to
B.Ed
go.
qualified candidate.
No, not to. He has chosen not to go undergone. Malad, he should. Malad lost his service. As per the NCT notification, everywhere my learned friend used to Malad show that notification, Malad. Everywhere, Malad. But I am not sure, Malad. This is the consequence of Malad.
Where will you obtain instruction?
Malad, I
Here
will
is,
come.
Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner prays for a category scale of pay in recognition of a training qualification. Mr. Vishwas, learned advocate, representing West Bengal Board of Primary Education, has prayed for accommodation. Since, according to the petitioner, the issue is different from other matters where this court has passed orders directing Commissioner of School Education to take decision based on the judgment delivered by Honorable Division Bench dated 30th July 2024, passed 30th July 2024, passed on intra-court appeal being MAT 1038 of 2024 within bracket Waliar Rahman and others versus State of West Bengal others. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading on 15 July 2025.
But I have similar candidate of Waliar Rahman, but I see this.
Let him come.
Yes. No doubt.
Next.
Because I have PhD.
Item number 6.
PSS.
Same murder.
Same
Two corner.
Kuporne means
as a training
Two corner. They want to opposite.
so well same order 15 July.
They want
Mr. Vishwas obtain instruction and come.
to immediate service.
How it is different? Yes. File your affidavit of service.
If they want, I have to.
ঠিক আগেরটা 15 জুলাই যেটা ফিক্স করলাম, ডিসপোজালটা নয়।
Because they all are self-putting candidates.
ওইটা কিন্তু জাজমেন্ট হিসেবে
Because my understanding contention is right, then my lord, no candidate whosoever pursue with BA.
Will
after
come back,
2019,
let him
they
come
are
back.
subject to-
Let him come back with instruction.
Yes, everybody is subject.
Item number 7.
Same.
Yes.
एक scale up pay same 15 July.
Item number 8.
এটা তো 7 হয়ে গেল। ও 7 হয়ে গেল।
I am appearing on behalf of the depiction of this. My lord, same identical matter, your lordship directed to file a report against student. Directed appointment, my lord, 2025.
That matter where Mr. Boisho appeared and opposed.
21-25.
Who also appeared. You are seeking a category scale of pay on being appointed in 2025
Yes, 2020.
from 2022 selection process. 2009, 14, 2022. 2009, 14, then 2022.
Panel estimate 2014, appointed 2021.
Now, Mr. Boisho submitted that it is different from other matters.
But it cannot show because the government, but in the other matter, find the affidavit or both consider to that.
Well, let it be 10 July, I have fixed it.
I'm for the state,
Ashok,
I'm for the state, my lord, led by Mr. KG Yusuf.
at the time of call, where is your affidavit of service? File it. You are for the state.
Yes, my lord, led by KG.
File your affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record. Client advocate representing parties have jointly submitted that a writ petition touching upon similar issue is fixed for consideration on 10th July 2025. So let this matter appear along with WPA 12116 of 2025. এটা এর সঙ্গে দিয়ে দেবে, বুঝতে পেরেছো? Next,
না কিছু বল স্যার।
where is Mr.
Sir.
Boisho?
স্যার item number 9.
Yes.
I am appealing for the state, my lord.
No order is passed. On the next date, Mr. Boisho's name will be there, if he appears. Yes, but he is not in my court. How he can appear at the same time in both, in two different courts? Not possible. Yes.
I will continue with the other.
When, who was the teacher? Who was teacher? Who was father, mother, or when he died? Father retired on? Yes. Died on? 1st December 2023. Mother predeceased father. Mother predeceased father. Mother died before father. Father's death. That is what I am asking you. So mother predeceased father. Yes. Yes.
23rd December.
Who? Husband died 3rd December 2020. Now, where is your widow daughter? Now, where is your legal heir certificate and income certificate? Where is your legal heir certificate and income certificate? Is it on record? 24. Page 24 is the issue the legal heir is not a legal heir certificate. So unless and until you issue the legal heir certificate is issued, no, nothing can be done. So what can be done? No, I don't have any determination. It's not an education matter. Move an application under Group 9. For legal heir certificate, court will not pass any issue any mandamus.
It is also under the decisions of the government.
Where is your income certificate?
Page 18.
You applied for legal heir certificate to the district collector on 21st March 2025.
Yes.
It will take some time. Unless until you deposit the legal heir submitted, how the DI will process your claim? In case of family pension of widow daughter or divorced daughter or unmarried daughter, legal heir certificate is must. Because widow of the deceased teacher can get a pension because she is the nominee in connection with service of the teacher concerned. But the daughter is generally not made nominee. So therefore, legal heir certificate is necessary. So if that legal heir certificate is not there, court cannot pass any order directing the DI to process your pension case. You have to submit legal heir certificate. Why you are coming at this stage before getting legal heir certificate? Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner, being widow daughter, has prayed for issuance, has prayed for settlement of family pension in her favor due to death of her father on 31st May. Due to date of her father on 1st December 2023. Stop. Father was a primary teacher who retired on superannuation on 31st May 2002 and was in receipt of pension, who subsequently died. Stop. Petitioner's husband also died on 3rd December 2020 and and it is submitted that petitioner is entitled to receive family pension being widow daughter due to death of her father. Next paragraph. However, on perusal of state respondents are represented by learned advocate who has submitted till date no legal heir certificate has been submitted by the concerned respondent authority for processing the claim of the petitioner for sanction of family pension. Next paragraph. Having considered the respective submissions made on behalf of the parties and taking and on perusal of the writ petition, it appears that an application for issuance of legal heir certificate by competent authority has been made on 21st March 2025 by the petitioner and till date legal heir certificate has not been issued. Next paragraph. Leave is granted to the petitioner to submit legal heir certificate along with other relevant documents before the District Inspector of Schools Primary Education, Paschim Medinipur, being respondent number 4. পশ্চিম বর্ধমান। হ্যাঁ, সেন্টেন্সটা কি বললাম দেখো তো। after legal year certificate is issued in favor of the petitioner by competent authority. Stop. If relevant documents are submitted before the respondent number 4, it is expected that said respondent number 4 shall take necessary steps in accordance with law for sanction of family pension. Writ petition stands disposed of. Urgent direct certificate.
Item number 10.
Yes, I cannot hear you. Yes. At the time of call, accommodation is paid for on behalf of the petitioner on the ground of learned advocate. However, state respondents are represented by learned advocate. Next paragraph lists the matter under the same heading in the monthly combined list of August 2025. Next.
Item number 11.
Yes. 2005-6. My order. I have passed order in your case previously. Yes. Show me that order.
One thing I just to indicate to his lordship, I have gathered information that one FMA 1029/2024 is pending before the division bench, wherein the issue is, my lord, that the only point involved in the instant appeal is whether the writ petitioner stroke respondent is entitled to a category scale of pay from the date when the result was published, or
yes, that
last
I
year
know
it
that
was-
this issue is pending.
Lordship.
But in similar other matters where Mr. Bhagavat Chaudhary is appearing for the petitioner, I have passed order in connection with 2005-6
Yes, ma'am.
candidates who completed this course, but the result was declared in 2012.
2011.
2011.
Fine.
That I have given direction for filing affidavits.
Lordship.
So where is that order? At least in 2 or 3 matters, I have passed similar order. Yes. Then where is that order? Not today. Bring that order.
So many matters he has all along. Entire list will be collapsed. At least 25 matters.
দেখি দাও ঠিক করে দিই না আবার সেই একই থেকে যাবে ম্যাডাম Yes, show me that your
একটা ব্রিক অন্তত দে আমাকে।
certificate, page 20. 2011 mark sheet was given. Where is the session? Which page? You are already enjoying a category scale of pay from which date? 2013.
11.
Now you want from 2006.
Yes. That has been traveled to the division.
Similar to the identically situated same council, the identical features.
Where is the session written in page 20? Page 20. Yes. At the top.
Top man. 2005.
2005-6. Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. By presenting this writ petition, inter alia, petitioner has claimed sanction of a category, sanction of a category scale of pay from 2006.
Yes.
Sanction of a category scale of pay from 2006.
June 2006.
Since petitioner completed primary teachers training course for the session 2005-6, but the result was declared belatedly in 2011. Stop. It is also submitted. by next paragraph. It is submitted by the advocates representing state respondents that petitioner has been sanctioned A category scale of pay from 2011. And it is also pointed out that on similar issue, it is also pointed out that similar issue is pending on Takeda. Similar issue is pending before the Honorable Division Bench in connection with one intra-court appeal
1029.
whether the benefit of higher scale is to be granted from the date following the date of completing the course or from the date of publication of result. Next paragraph. Since petitioner is in receipt of A category scale of pay from 2011, issue needs to be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 4 weeks from date stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavit. All parties are present.
But I'm for the state.
Who are the other parties?
But I'm led by Mr. Miss Ponaroy Chaudhary.
Next. Give your appearances.
Yes, ma'am.
Item number 12.
But I'm for the statement.
Same.
Let same order be passed, Mr. Chaudhary. Affidavit of service. Same order.
Upon mentioning that.
Item number 13.
13 also not same.
One after another. Same order. Here for the district primary school council. Which district?
Item number 14.
Your Lordship, I appear
Same
for the state. Same issue. 14.
Affidavit of service. Same order.
Yes, sir.
Item number 15.
Let other matters be called on. Similar other matters where Mr. Chaudhary is appearing.
Yes, my lord. Next 5
Yes.
matters, my lord.
Yes.
From 16 to 24. All.
Yes. One after another.
এখানে দিয়ে দিন একবার দিয়ে দাও পরে ওকে দিয়ে দিস তাহলেই হবে মনে করে দিয়ে দিস। এটা রেখে দে এটা ঢুকিয়ে দে।
Item number 16.
I'm for the state.
15 is Passover. 16,
I'm for the state.
16, same order.
Dada.
Item number 17.
17 also, my lord. Same.
Take it out. Same order.
Item number 18.
Same. I'm appealing for state.
Same order.
Item number 19.
Same issue.
Same issue.
No. Same order.
Item number 20.
Time for the state respondent.
Give your evidence.
20.
Same order.
Item number 20.
20 also, my lord. Same issue.
Same order.
Item number 22.
21.
Item number 21.
I am for the state with Manoj.
Same order.
Item number 22.
Same issue.
Same order.
Item number 23,
Grateful, madam. We are for the state, same order.
item number 24,
For the state, madam. Same order.
আর খুলিনি এগুলো, এগুলো সার্ভিস গুলো সব ওরকম করা আছে।
হ্যাঁ, সেটাই ভালো হবে। হ্যাঁ। কেন অনেক
আর নেই তো?
তুমি এত টোটো
আর
order
আছে?
পাই- হ্যাঁ, এটা পাঠিয়ে দাও, ঠিক আছে। হুম, হুম। Those matters will be taken up later. Yes. Then I will call first 15 and other matters. Other matters from 25.
এখানে থাক। ঠিক আছে। না, আগে আছে তো। স্টেটের মামলা আছে।
Yes.
Item number 15.
Same issue. Which is fixed on 10 July.
No, my lord. No. 2021 appointment is 21.
So B.Ed candidate. To make a further representation. এই শোনো এমনি ঠিকই আছে শুধু না এই চেঞ্জেস গুলো একটু দেখে নেবে লিস্ট বানানো disposed of.
I'm all obliged.
Yes, call the next item. 25.
Item number 25.
They were qualified and they were applied as trained candidates in the 2016 recruitment process.
Yes.
Now, thereafter, when the panel was published, all trained candidates were appointed, petitioners were not appointed. In 2017, I am talking about petitioners filed the written petitions.
Disposed of.
Before the matter could be taken up, petitioners were appointed. And accordingly, my lord, the matter was withdrawn as non-prosecution because petitioner has been appointed trained. And thereafter, my lord, petitioners are receiving salary in the
Date qualified, 2014 date qualified, 2016 selection.
Selection process, participated, initially not treated as trained candidate and not appointed. Petitioner approached this court. During pendency, petitioners appointed, matter was withdrawn. Thereafter, my lord, petitioner was receiving salary, A category scale of pay from 2018 because of those trainings. Now, my lord, petitioner were of the impression that they were trained candidates. Subsequently, my lord, the lordship knows the coordinate bench terminated appointments of 32,000 candidates.
Being untrained.
Being untrained, but petitioner's appointment was not cancelled. Petitioner was trained.
But pursuant to my lord, in order of the coordinate bench, the West Bengal Board of Primary Education published a breakup of marks of all-
Against training qualification, the space was kept blank. But in the morning, I have passed an order. In the morning on same issue, I have passed an order that cannot.
So I have, your lordship has passed an order, my lord, I have.
That cannot be tweaked at this stage because you participated as untrained candidate at the material point of time.
No.
Oh.
At the relevant point of time, I participated as a trained candidate.
Show me that your application is trained candidate.
My lord, page number 46.
Because in the morning first matter, I was considering where TET 2014 candidate trained 16, but certificate was issued in 2017.
No, I have my certificates all were before.
Oh.
My lord, page 46. My lord, this is the highest court. My lord, this is the petition number 1, page 46. Kindly see, this is my online application form for.
Yes, trained.
My lord, next, my lord, page 50.
Now, where is that list? Breakup of marks?
114 marks. Page 114, quote from the bottom, petition number 1.
Yes, why this space was kept blank? Petitioner participated as trained
And
candidate.
I have my certificate also.
Let me show one example. I have not checked all of them. Bishwajit Devnath.
No, please come to page 114, Polash Bangal.
But that's why I'm showing another example to your losses. Because
The issue which I am considering in connection with petition number 1, you make submission.
your losses page.
That is in terms of in accordance with my convenience.
No, your losses do that certainly.
Yes.
Which is referring to
114.
114.
Yes.
Yes.
And now fourth from bottom.
Polash Bangal.
Yes. Yes.
Bangal বিশ্বাস করা মুশকিল। Anyhow, let's see one.
Now the training score is not there.
Page 46 is my application form.
Just a minute. Categories training score is kept blank. But petitioner participated, page 46. Mr. Shanna, please come to page 46. Polash Bangal. Trained.
Just
Yes, yes.
এটা ভার্বাল অর্ডার হয়েছে
In case of obtaining certificate in 2017, in the morning, I have clarified it. So that cannot be changed because your participation as untrained candidate and that breakup of marks is in connection with 2016.
This is the exact document where your lordship wanted to see. This
Yes.
is the exact
Page
document.
21, if your lordship wants. Page.
No, it's varies petitioner to petitioner. Then you'll also confined to one.
No. Petitioners, all petitioners are there.
No, that's why I'm showing to your losses.
Yes.
Kindly,
Show me any other example where there is
your
discrepancy.
losses kindly come to. Yeah, please.
So far one is concerned, there is no discrepancy.
No,
But I do not know
I'm
with regard to other
I
candidates.
will take instructions on this.
Yes.
Now your losses, one example, page 22.
Page 22.
Polash Bangal. Certificate of 2022.
No, this is my page 21. Kindly see my lord. This is my
Eight kothay?
page. And
They've not
National Council of Teacher Education is on being applied there. Kindly come to page 21.
No.
This is my thing.
Karnataka Secondary Education Examination Board.
My lord, initially, why
Now
I
I
was
tell
not
you, my
treated
lord.
as trained candidate at your lordship since
Now you
my
lost.
training was outside the state of West Bengal. They could not verify. It was that stand. They could not verify. Subsequently, they verified and appointed me as my training. It was because all of them are
Now,
outside.
my lord, 2, Vishwajit Devnath.
Vishwajit Devnath. So regarding petitioner number 1, there is no controversy.
No, I will take instruction, then I will make submission because they don't have any instructions. I'm just, my lord, right now saying.
Random, you are searching that where if there is any.
My lord, that's your loss.
weakness so far this petition is concerned.
Page 28.
Page
28.
28. Yes, page 28.
Certificate was issued, my lord, bottom 8th February 2019. I don't know, my lord, how she can be described as
This is
trained.
from National Council for Teacher Education.
Now, Mr. Dasgupta, show me that you appeared as trained candidate.
My lord, in respect
Petition number
petition
2.
number
2. Vishwajit Devnath.
50, my lord.
50. Yes, 50. Trained candidate.
No, my lord, once might have applied as trained
Page 27.
without being trained. Then what would happen?
Page 27.
Then you will cancel his candidature
My lord,
for
probably
misrepresentation.
untrained পেয়ে যাচ্ছে তার জন্য
My lord,
চাকরি দিয়ে দেওয়া
his
My lord, page 27 kindly comes. I have my.
I'll stand corrected after instruction on facts. But if this happens, your lordships, he was considered as untrained
Petition
in a
number
situation.
Page 27 kindly see.
So that's your
Page
lordship.
27.
And why only these 4 petitioners?
Yes,
Very difficult.
come to page 27, Mr. Sanna. In connection with petitioner number 2, which you are trying to point out. Vishwajit Devnath. Dear Directorate of School Education, Itanagar. Diploma in Elementary Education.
And 2000 kindly see.
Lord, kindly, very down. Page 27, registered number, your lordships kindly see.
Now
No, but it can't be. And your lordships will find in the certificate any registered number, registration number.
Where is the registration number? Page 27.
Page 27.
Yes, registration number 2008.
My lord, kindly see the certificate. Certificate must, my lord, show the registration number. In all our certificate.
Means it's
Page 28. Page 28.
No,
No,
28 is not.
28 is in connection with National Council for Teacher Education.
Oh, your loss is certifying what? Certifying what? That he got the pass certificate from Arunachal. Kindly have a look at it if I'm
This
not
is
wrong.
NIOS. This is National Council for Teacher Education certificate.
Kindly have a look at this. He has passed out diploma in elementary course from Diet Rowing, Arunachal Pradesh.
Yes.
Kindly have a look, page 27. This is also Diet Rowing, Arunachal Pradesh.
Same person.
So it must not saying the same.
Yes.
Therefore, this NIOS do not, my lord, incorporate the registration number. I have to check it up. And
There is often instruction comes.
that's your loss.
My lord, only one thing. I have been receiving a category. They have verified. Now can they say this certificate?
Right. In recognition of qualification, a category is granted.
No, my lord, with the certificate of scheduled caste appointed, subsequently verification found that the certificate is fake. Now I can't take out the certificate.
Yes, obviously you can take, but that is not the case.
Do that.
Mr. Shanal, that is not a case. It's a mere preparation.
Case, my lord, my case, I do not know even.
Very well, obtain instruction and come back. Affidavit of service filed on behalf of the petitioners is taken on record. Next paragraph.
Now,
Next paragraph. Document in support of depositing deficit court fee is also filed. Next paragraph. Petitioner prays for publication of correct list containing breakup of marks in connection with 2016 selection process, where petitioners participated and got selected. At present, petitioners are working as primary teachers and a category scale of pay has been sanctioned in their favor. Next paragraph, Mr. Sannal, learned senior advocate representing West Bengal Board of Primary Education, has prayed for accommodation to obtain instructions. Next paragraph, hearing of this matter stands urgent. Next paragraph, lists the matter under the same heading on
Instruction
21st July 2025.
Item number 26.
Yes.
Calculated wrongly. That's why you keep the right after that.
Who is for the state? Nobody is appearing. You are not. Who is for the state? In connection with sanction of 18 years benefit, state and the chairman Murshidabad District Primary School Council are the relevant parties. When you have served, check it up. June. Serve another notice, come back. Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. No one appears on behalf of respondent authorities. Next paragraph. Learned advocate representing the petitioner is directed to serve notice upon the learned advocates representing the state respondents and District Primary School Council, Murshidabad. Stop. Murshidabad, enclosing copy of this order by 7 days from date. Next paragraph, hearing of this matter stands adjourned. List the matter at the same hearing on 15 July 2025.
Next matter.
Same. If
call
the matters one after another. If other side appears, then
Service,
matter can be taken up.
আগেরটা চুয়ান্নটা হ্যাঁ পঞ্চায়েত ঠিক আছে item number 27.
I beg to appear for the state ballot. Need instruction from the department. Just have received 3 days back.
Will also kindly consider also page 32.
He is praying for taking instruction. File your affidavit of service. Murshidabad District Primary School Council. Issue. Affidavit of service filed on behalf of the petitioner is taken on record.
1256.
No one appears on behalf of respondents excepting state respondents. On behalf of respondents excepting state respondents. Next paragraph, learned advocate representing the state respondents has prayed for accommodation to obtain instruction. Next paragraph, learned advocate for the petitioner is directed to serve notice enclosing copy of this order upon the learned advocate who represents District Primary School Council, Murshidabad, by 7 days from date. Next paragraph, list the matter under the same heading on 15 July 2025.
Grateful.
Next.
Item number 28.
My lord, in item 28, I am representing state respondent, my lord. My lord, I need time to take instruction, my lord, identical to 27, my lord.
Where are
tomorrow I am leaving for Calcutta, my lord. My exams are over, my lord.
Never stay at Kolkata. Mr.
My lord,
Farmania,
my lord,
you
I'm a
never
single
stay at
father.
Kolkata. Always you appear from Delhi.
My lord, tomorrow I am leaving, my lord. On Monday I will report physically before your
No.
lordship, my lord.
Who is your junior? Yes. You are the panel advocate or you are junior to Mr. Farmania?
No, she is in panel.
Panel
my lord.
advocate. Acha, tale kaaj karo issue. Same issue, 18 years benefit. I am asking you, 18 years benefit. Affidavit of service filed on behalf of the petitioner is taken on record. Learned advocate representing the state respondents. Learned advocate represents state. Learned advocate appears online, who is representing state respondents. And prayer is made on behalf of the state respondents to obtain instructions. No one appears. No one appears on behalf of other respondents. Next paragraph, learned advocate for the petitioner is directed to serve notice enclosing copy of this order upon the learned advocate who represents District Primary School Council, Murshidabad, by 7 days from date. List the matter under the same heading on 15th July 2025. Next.
Obliged, my lord. My lord, on Monday I am coming physically, my lord, to bow down before your lordship.
Item number 29.
29, my lord, I am for the petitioner. This is my affidavit of service. This is for grant of notional benefits in favor of the petitioner. The petitioner participated in the 2014 TET, my lord. He was just shortfall to secure the cutoff score, the qualifying marks.
6 marks.
Yes, my lord.
Date 2014, 6 marks. Mr.
Yes.
Biswas, it is the same matter where I have
Yes.
directed from 17 February.
Identical matter. My lord, I have the order of your lordship.
I have passed order
Yes, my
in
lord.
Mr. Dasgupta's
Yes,
matter.
yes, identical to this matter. The coordinate bench also decided the issue and they have complied the order also.
Just a minute, let me see the matter. When you are appointed?
Well, I'm appointed on 7th of October 2021. My appointment is of 5th of October 2021. I have
October 2021.
Yes, madam.
Single petitioner?
Yes.
ওটাই হবে একটাই কিচ্ছু হবে একটা হ্যাঁ তাহলে শেয়ার ভালো টাকার কথা
Are you relying upon that memo dated 3rd April 2025 issued by the Chairman District Primary School Council, Bankura?
But I am relying upon the memo I have annexed at page 64. Identical situation.
This matter is from Murshidabad.
No,
My matter is from Nodia. Well, this pertains to
DPS
Murshidabad.
এ হবে অভ্যাস হয়ে গেছে তো এটাই না এখন এমনি অভ্যাস হয়ে গেছে এখানে আছে তো ঘুম আছে মুর্শিদাবাদ এটা মুর্শিদাবাদ আমাদের কিছু করার নেই, মুর্শিদাবাদে পাচ্ছে অভ্যাস হয়ে গেছে করে দিল
Same order be passed. এই কিছু ওই যে কোনো করলে বুঝতে পেরেছো কালকে সই করে দিলাম যে কোনো একটা কারেকশন হয়েছিল
Authority to grant notional benefit.
Yes.
Side, both the fact side is
I've annexed the memo of the commissioner also.
Lordship directed the Commissioner of Education.
To grant benefit,
Yes, yes.
not consideration.
Not consider, Lordship.
No,
Yes,
not
yes,
consideration.
order I have seen.
Reasonable.
No.
Mandatory order, Lordship.
I have mandatory order. Yes.
I am saying so.
Not consideration.
No, no, consider the mandatory order to consider.
I have directed the Commissioner of School Education to pass an order relating to refixation of pay by granting notional benefits
Personal benefit
within
for
12 weeks.
time, not any future.
Yes.
Correct.
February 17.
Item number 30.
Yes.
The categories scale up pay, my lord, fix the matter.
10th July, my lord. Appointed.
Where Mr. Boisho has opposed. No, this is not the same matter. You are ready.
Yes, I have received
Mr. Sharnal is also ready. You are also ready.
Total, I love this. Sandal is Lordship better than.
He is Sharnal is?
Better.
That I do. That I do not know. Yes. At the filed affidavit service. এসো তো একটা order করে নিও মনে অনেকগুলো matter আছে. Affidavit service filed on behalf of the petitioner is taken on record. It is submitted by the learned advocates representing the parties that on the writ petition, writ petition
WP 12116
touching upon similar issue. Yes, writ petition touching upon similar issue is pending consideration before this, is fixed for consideration on 10 July 2025. So, next paragraph, let this matter appear along with WPA 12116 of 2025 on 10 July 2025. In first matter, you will file a report. In other matters, there is no necessity. Yes, yes.
39.
Yes, one after another. Not in this fashion because state respondents are there.
Item number 31.
Who is for the state?
Led by Mr. Bosumalli.
Sumonli, yes. Yes, same order, 10 July.
Same order চলছে এখন, হ্যাঁ?
Item number 32.
Mr. Dotto, you are appearing for the state.
State lordship.
Affidavit service, same order. Give appearance 10 July because lead matter is fixed on 10 July.
Today come with a report or affidavit in the meantime.
Affidavit is not required. Only report you can file on the next date to assist this court.
Very good.
Because it has been contended by Mr. Boisho appearing for the District Primary School Council, not 24 Parganas, that the prayer is so far the case of the petition is concerned, it is different from other case where order was passed directing the director of school, commissioner of school education to take this. So how far it is different, that has to be demonstrated before this court on the next date.
Lordship.
By directed the commission chairman District Primary School Council, not 24 Parganas, to file a report disclosing how it is different from other matters where court has directed commissioner to take decision
Lordship.
regarding grant of A category scale.
Lordship got it.
Yes, same order, 10th July.
Item number 33.
ওদেরটা কত? পরেরগুলো কত?
And in this matter, Mr. Sharnal has changed his side. He is appearing for the petitioner, not for the board.
Side change করছিস?
In the lead matter,
The lead matter, but his lead
it
is
is for the
different.
petitioner.
Now the role of the leader is different.
A lawyer cannot have any side.
Yes, yes, right, right. Same matter, 10 July.
Item number 34.
34, my lord, I am also appearing for the state respondents. 34.
Yes, Mr. Dotto, since you are appearing in this matter, take instruction.
I think I,
Make submission to assist the court.
of
Whether
course,
it is a
definitely,
different matter.
definitely, I'll do. Definitely. will.
In 2021.
Court is considering a grant of A category scale of pay.
Yes, I have.
Whether an order is passed, directing the commissioner of school education to take a decision. Now it was specifically and vociferously argued by Mr. Boisho that no, it is not same matter.
So to that extent, with your lordship
Yes.
request assistance. Lordship, I'll
10
try my
July, same order.
in July, same order. These appeals.
Item number 35.
But this 35 also I am appearing.
You are appearing in 30, in 35?
35 also.
Yes. Same
Same order.
order, 10 July.
Lordship.
Because ultimately direction is to be given upon the commissioner. You are
I
representing.
know, yes. I'll be representing the commissioner. Lordship.
Item number 36.
This is for the state, my lord.
Yes, give your appearance.
Yes, sir.
Same order, 10 July.
Yes,
it will appear along with other matters.
Item number 37.
No. Same order, 37, who is for the state? 37, who is for the state? স্টেটের কোনো নাম দিও না, ওই এটা চেঞ্জ করে দেবে দরকার পড়লে ইয়েটা সেন্টেন্সটা।
Item number 38.
I'm appearing for this.
You are for the state.
Yes, your lordship.
Same order.
Item number 39.
Who is for the state? Same order, 10 July.
Item number 40.
40, my lord, I am for the petitioner, my lord. This is identical to item number 29, my lord. Grant of notional benefit.
Same order be passed. Subendu, notional benefits যেটা দিলাম from February 2017, when you were appointed.
Same date, 7th of October 2021.
7th October
2021.
Same date.
Same date.
Disposed of Calcutta. Female candidate she হবে দেখে নি disposed of.
Applies.
40. Item number 41.
Not today, my lord. The advocate on record has viral fever.
Justin. At the time of call, accommodation is paid for on behalf of the petitioners. Or petitioner, single petition. Accommodation is paid for on behalf of the petitioner since the learned advocate is unwell. You are for the state.
In the next one.
Who is appearing for? No one appearing for respondents. No one is appearing for respondents. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading. On 21st July, or list the matter under the same heading in the monthly combined list of August 2025. Next paragraph, learned advocate for the petitioner is directed to serve notice upon the learned advocates representing the state, serve notice upon the respondents or the learned advocates representing those respondents, enclosing copy of this order by 10 days from date and file affidavit of service on the next date. Next.
Item number 42.
Who is for the petitioner? You are for the petition, yes. Waliur Rahman. Yes, Mr.
Only what is troubling me, on the basis of he asking for the category certificate, DED certificate. But I am not finding DED certificate.
They will take instruction, come back.
No, he has to annex. Not annex to the petition.
Where?
With mark sheet, page 19.
19.
Then your lordship, I do not know whether state is the appropriate authority to assist your
Let
lordship.
the direction
Then
is
can
given
you
to the
go to
commissioner for
Nandi?
education, let the original copy has been submitted.
No.
If the- No, I am directing to submit a representation along with relevant documents before the commissioner.
Yes.
Commissioner will take a call.
Yes. Whether this certificate is equivalent or the
So that the commissioner will take decision. Why before that court will embark upon this? And court is directing to make a representation with supporting
connection
documents.
With document lots.
There are certain issues in all matters.
because what strike the Bundelkhand University Jhansi,
That is the recognized
certificate is otherwise valid.
Or not.
Then Malad is
Then
entitled to
Lordship,
get it.
Otherwise not.
If this institution is
That
not
Lordship, my
recognized,
learned headback objection has been Lordship noted.
My lord, on the basis of these documents, he got appointment. 2020 appointment.
Okay. On the
That's true. As trained candidate, no.
Yes, my lord.
Yes. As trained candidate,
Trained-
because
Trained candidate, he was appointed.
otherwise,
Yes.
Your board has permitted him to be
no,
appointed.
not both, Malad. Malad, board, and on the basis of the training, Malad, the government would allow everyone. After scrutiny verification, Malad, subject to Malad, verification, but he was allowed to join. But ultimately, if it is found, Malad, this certificate is not as per requirement.
You can take steps. You can take steps, but till he is being considered as trained candidate, he is entitled to get a academic scale of pay.
Absolutely.
Bundelkhand Jhansi.
I'm extending the time instead of 12 weeks, 16 weeks. Because how many matters commissioner will take decision within certain time?
Other than regular work.
It is not possible.
Then Lordship file the contempt application before the
Yes.
commissioner does not comply the Lordship's order. When the matter was hard day to day, Lordship 1 week, 2 weeks, 3 weeks extension, Lord.
Because there is no urgency. You are working only whether you will grant, you will get the scale of pay or not. If it is decided, you will get. Yes, same order. Correction গুলো একটু দেখে নেবে disposed of.
Item number 43.
43, I'm for the petition, my lord. This is my affidavit of service and deficit court fees, my lord.
Yes.
Sir, may I pray for one indulgence, my lord? My lord, subject
Will
involving
you,
this writ petition has been, or is your lordship is also considering in another matter, my lord. Your lordship has been pleased to fix that matter on 1st of July. Mr. Bhattacharya is appearing in that matter. This is the order passed in that matter, my lord. This
As
is
cut-off date.
No, this is relating to the appointment of the petitioners against the remaining vacancies, my lord, unabsorbed candidates, my lord, pursuant to the Supreme Court's direction, my lord, the board needs to complete the selection process soon. So, my lord, let that matter be decided first. Your lordship kindly take it up after 1st of July, my lord.
So there was an amendment of rule. Mr. Sharnal took this
Yes,
point
yes.
that the rule was amended.
Amended, yes.
The very first point which was agitated on behalf of the petitioners,
Yes.
that point doesn't exist.
Yes. Well, let that be, my lord, decided first, my lord.
If you pray for time, then I will place this matter in the monthly list of August. All matters cannot be clubbed together in this fashion.
No, I'm not praying for clubbing, my lord. Let it be placed after the 1st July, my lord.
Issue.
I paid the deficit quote.
Affidavit of service filed on behalf of the petitioners is taken on record. Next paragraph. Documents are filed document is also filed in support of putting in deficit court fee. Next paragraph. Lawyer advocate representing the petitioners has prayed for accommodation. You have not served notice upon anybody.
Yes, I filed the deficit.
Yes.
Affidavit of service, my
Respondents are not represented today. Oh,
Yeah, I'm happy. Led by Mr.
very good. List the matter under the same heading on 21st July 2020.
I'm deeply
Next.
Item number 44.
grant of notional benefit, my lord. This matter is identical to item number 4, my lord. Your lordship passed an order in item number 4 today, my lord. This petitioner participated in the 2014 TET, my lord. She was unsuccessful, my lord. My lord, pursuant to this honorable court intervention, my lord, 6 marks was awarded and she was qualified in in February 2022. She was appointed in March 2022.
সকালবেলা কি অর্পণ ছিল?
অর্পণ
সকাল
তখন
অমিত নিয়েছে।
Coordinate bench also decided the issue,
Mr.
my lord.
বিশ্বাস was appearing in this matter. That is from 2021 to 2022.
Yes, page 42 is the
2020
identical.
selection process.
No. Appointments were made in 2021 and petitioner was appointed in 2022.
Absolutely.
Yes.
In connection with 2020. Let same order be passed when petitioner was appointed.
Let's see, appointed on 25th of March 2022.
25th of March 2022.
He joined the next date. Appointment is of 25th March.
When joined? Joining
Date, 26th March 2022.
appointment means date of join. I'm not asking you to apprise this court the date of appointment letter. 26 March 2022 joined. You are seeking the court directed that from the last date of the last date of appointment of a candidate in connection with 2020 selection process in the concerned district, notional benefits is to be granted, and in this regard chairman shall pass an appropriate.
Yes, I have followed.
Absolutely.
You are for the chairman.
DPSC Nadia unnecessarily made us party.
No, I have directed the chairman to decide.
Murshidabad is the
Related to Murshidabad DPSC. Even I have made party
Murshidabad
with
DPSC is
Murshidabad and Nadia also, madam.
Nadia is wrongly made, because I do not have any role.
Who is for Nadia?
I am for the Nadia,
And who is for Murshidabad?
Mr. Jahan for
Tarwar Jahan.
Tarwar Jahan.
Where is he? He was there few minutes back.
না ওর একটা ভুল হয়েছে কি ওর কাউন্সিলটা মুর্শিদাবাদ আর চেয়ারম্যানটা নদিয়া করে ফেলেছে কপি পেস্ট করেছে
May I serve or come back again?
Yes, serve another notice and come back.
This will be.
And come with that order today which I have passed.
Yes. Item number 4.
I will take.
Have annex 1 and order of coordinate bench, my lord. Similar issue, my lord.
No, because there is a change so far giving benefit of notional benefits from a particular date.
That
So
I have
therefore
followed.
bring that order. Issue.
এই অর্ডারটা
Affidavit of file your affidavit service. Affidavit of service filed on behalf of the petitioner is taken on record. And no one appears on behalf of District Primary School Council.
No, my lord, this is my mistake, my lord. Perhaps, my lord, District Primary School Council has not been
Take
served.
it back.
I shall file a fresh, my lord.
না কারেকশন চা এটা কারেকশন করে
Correction
Party
করে
করা
নেই। নদিয়া
না
deleted.
নদিয়া কাউন্সিল পার্টি করা আছে চেয়ারম্যান এই মুর্শিদাবাদ কাউন্সিল পার্টি করা আছে নদিয়ার চেয়ারম্যান
as prayed for কি বললাম
আমার
বলতো
আন্ডারে নয়
sentence
তো।
টা? No one appears on behalf of District Primary School Council, Murshidabad. Being respondent numbers 7 and 8.
No, 8 is different.
Next paragraph. As prayed for, leave is granted to the learned advocate representing the petitioner. ঠিকই বলেছে এখন দরকার নেই। No one appears on behalf of District Primary School Council, Murshidabad. বাকিটা কেটে দাও। As prayed for, leave is granted to the learned advocate for the petitioner to amend the cost title in course of this day and describe Chairman District Primary School Council, Murshidabad appropriately against respondent number 8.
Yes.
Stop. After such amendment is carried out, learned advocate for the petitioner is directed to serve notice upon respondent number 8 by 10 days from date. In addition, thereto, notice is to be served upon the learned advocate who represents District Primary School Council, Murshidabad, enclosing copy of this order.
Nodia may be deleted because it's an unnecessary party.
ওইটাই তো
Correction, I have directed correction. Why deletion? Correction.
ওটা করলে তো তোমার অটোমেটিক হয়ে যাবে
বেকার হয়ে যাবে
List the matter under the same heading on 15 July 2023.
I'm council.
Item number 45.
Five is grant of notional benefits, my lord, and identical to item number 29.
That is 2016 selection process.
Yes, your lord.
Date of appointment
7th of October 2021.
Copy of the order. Do you have only that?
Yes, yes. I have.
Who is for the you are for the board? Whether in state is represented?
Yes, ma'am. I am appearing on behalf of the state. I am for the DPS.
Nodia.
Nodia.
Copy of the order.
They're relying the commissioner.
Already I have decided the issue in other matter. Directing to grant benefits from February 2027, notional benefit. আচ্ছা শোনো ওই নোশনাল বেনিফিটে ফেব্রুয়ারি 2017 যেটা দিচ্ছ
Well, this is the order.
appointed on in 7th October 2021.
Yes.
And where is that memo of Murshidabad, Chairman Murshidabad? Yes, page 57.
My lord. Page
28
57.
April, yes.
Same.
Same করে দেবে কারেকশন করে তো
না এখন অর্ডারটা দেখুন
আমি তো
male candidate same order. Next.
Item number 46.
Yes. What you are praying for? I couldn't follow. B category to A category training.
Yes, Malak, he's completed the training 2014 to 2016. Here, Malak. Then he is joining the July 2016, Malak. There are result published on August, Malak. They are from the date of joining. My salary is increment has been claimed, Malak. From the date of joining.
In connection with which selection process?
Yes, no selection, kindly see, my lord, page 31. The memo, my lord. This memo.
Who is appearing for the respondents? Who is from the board? Are you appearing?
I'm don't know
I'm-
the party or not.
The chairman also, my lord, the chairman shall.
Why board has not been made party?
No, my lord.
Because selection process was conducted by the West Bengal Board of Primary Education. So board should be made party.
Chairman of South Bengal District Government School Council.
16 selection process was conducted by the board. Board has to be made party.
DLS course, my lord. 2 years DLS course, the chairman of South Bengal DPSC by the chairman of injection. Then by the South Bengal B category to A category.
Question is whether you participated in the selection process as trained candidate.
For in-service candidate.
I am asking you whether you participated in the selection process as trained candidate or not.
No. Yes,
No. No, answer the query of the court. No, you participated in the selection process as trained candidate or not? Yes or no? I couldn't follow. Please don't waste court's time. If you are not ready with the matter, then pray for time.
May I assist your lordship? My lord, petitioner appointed July. Your lordship will.
July 2017.
2017. My lord, just.
No, 19.
My lord,
19.
my lord, just a minute. No, sorry, my lord. 2019.
No, 19.
দাঁড়ান আমাকে একটু 21 থেকে আমি বলে দিচ্ছি সবটা।
Praying A category scale up pay from 1st July 2016.
That cannot be.
That is the prayer.
That cannot be. That is why, my lord.
Therefore, let the board be added as party. You and matter be fixed on the next date. You come ready.
Page 38. Your lordship will find.
As prayed for, leave is. Where is your affidavit of service? Affidavit of service filed on behalf of the petitioner is taken on record. As prayed for, leave is granted to the learned advocate for the petitioner to amend the constitution and add West Bengal Board of Primary Education and its president or secretary, secretary and its secretary as additional respondents in course of this day. After such amendment is carried out, learned advocate for the petitioner is directed to serve notice enclosing copy of the writ petition and copy of this order by 10 days thereafter upon the additional respondents. Stop. List the matter under the same heading for further consideration on 21st July 2024. Then it will be accommodated. You will be accommodated.
Item number 57.
I'm for the petitioner, my lord. This is with regard to issuance of TET pass certificate with regard to TET 2014, my lord. TET pass certificate. With regard to TET 2014, my lord.
This is the last order.
Yes.
This is the last order.
22nd May. 22nd May.
This is the last order, my lord. June.
Court fee?
Yes, my lord. I have handed over.
Mr. Vishwas, let same order be passed.
Same order, the last order your lordship has, my lord.
Yes, 19 June 2025 order.
19 June their order দিয়েছে আমি.
Yes.
Because there are certain conditions which are
exactly
attached
19 June.
based on your submission made.
Absolutely.
We have to hand over some documents to them.
How many petitioners are there?
11 petitioners.
19 June. নাম্বারটা লিখে রাখ।
এই শোনো, সেম অর্ডার করবেন, ডিসপোজড অফ।
But only once, may I go through your lawsuit last order? I'll take that my lord number.
ইয়েস, ওকে একটু দাও তো রেফারেন্সটা নিয়ে।
Just wait, I will take the reference.
নেক্সট ম্যাটার,
Obligement.
item number 48.
I am for the same.
ইয়েস, 10 জুলাইয়ের অর্ডারটা তুমি নিয়েছো? ম্যাটার্স আর ফিক্সড অন 10 জুলাই along with the first matter. Same order, 10 July fixed. Yes, next.
এই যে এফিডেভিট সার্ভিসটা
Item number 49. State, এফিডেভিট সার্ভিস আমাকে দিতে হবে। 10 July, same order.
50টা নেই, 51 to 59.
Item number 50. 50 will be taken up later. Next 51, same order. 10 July. 51. 50 Passover. 51, 10 July.
Excuse me.
Same order.
It is slipped
10
up.
July. Go on calling. 52. 10 July, same order.
কাগজ দেবে দাদা, অ্যাপিয়ারেন্স দেওয়ার জন্য স্লিপ চাইছে।
Item number 53. 10 July, same order. 54. Same order, 10 July fixed. Yes, then 55 over matter 50. 55 I think is a different matter or same? Same order. 10 July. 56. Same order, 10 July. 57. Appearances 57, yes. 10 July, same order. 58. Same order, 10 July. 59. Then at 2 p.m. This matters under this head will continue. First Passover matter 50 will be called. Come back at 2. Please call the list.
Item number 50.
Yes, Passover
Item
matter.
number 50, before your lordships had risen, my lord, I had prayed before your lordship that I would be my lord, seeking a day's adjournment, my lord, for the reason that, my lord, I need to prepare myself in this matter. Kindly takes it up on Monday, my lord.
Lordship, I am informed that the board is a party, but I don't have the copy.
Yes, my lord.
Kindly a
I
copy be
have checked the
given to me.
affidavit of service. It has been sent, my lord.
Might be
Probably it has
sent.
not reached.
At the time of call, learned advocate representing the petitioner has pressed for learned advocate representing the petitioner pressed for accommodation since service of notice upon all the respondents is not. Next paragraph, learned advocate for the petitioner is directed to complete service of notice upon all the respondents at file. All the respondents by 10 days from date and file affidavit of service. List the matter under the same heading on 21st July 2020.
21st July.
So very grateful.
Next.
Item number 60.
The 2005-6 session 2011 received benefits.
For the state, my lord.
এই শোনো ইয়ে অর্পণ কি নিয়েছে বলতো লোটার গুলো
কত নম্বর আইটেম যেন? 11 রণজিৎ নিয়েছে।
রণজিৎ বলবে একটা এফিডেভিটে ডিরেক্ট ডিরেকশন করে
21/7
বলা আছে যে same order is
কবে হলো?
4 weeks, 2 weeks.
Item number 61.
I'm appearing for the state respondent led by Mr. Shantanu Kumar Mitra.
না same order.
Affidavit, 4 weeks, 2 weeks. Divided in
19th July.
Item number 62.
Yes, but I am appearing for the
State, you are for the state.
State respondent.
And DPSC Hooghly.
State respondent, 62.
Same order. Give your appearances.
Item number 63.
Same.
Same order.
Item number 64.
Same lot.
File your affidavit services. Same order.
Item number 65.
It's different.
65 Passover.
65 Passover.
Wait, similar matters, let it be. Passover for the time being, wait.
Item number 66.
Same order. Same lot.
Same order.
Item number 67.
Same order.
File there. File there. 12,801। Item number 68.
Same order. Same.
Same order.
Item number 69.
No other matters?
Yes, ma'am.
How many?
71. 71, then 73, then 75, then 70.
Yes, call these matters first. 70, call item number 70.
70.
70.
Item number 70.
69 Passover for the time being. 70, same order.
Item number 71.
Same order. Same.
Same order. 72 passover for the timing.
Item number 73.
My lord, I am for the state respondent.
Give your appearance. Same order.
নিয়ে নেবেন একটু
So up to 73.
75.
75 and
একটা কাগজ দিন না। Item number 75.
75. Same order.
Yes, ma'am.
74 passover for the timing. 75 same order.
Item number 77.
76 passover for the timing. Then call 77.
হয়ে গেছে তো?
77 same order.
একটু নিয়ে নেবেন একটু।
Yeah. Arrange it accordingly, accept the appearances of the learned advocates, and then call from 65.
এইটা একটু দিয়ে দিন না। Item number 65.
This is inter-district. May I file one?
Who is for the district primary school council? And
I
court.
My lord, I appeal for the state only. I am appeal for the state only.
Chairman district council is required to be represented.
Mr. President, I have served him. I have just now I have informed. He said my junior will be there.
So chairman is to take decisions.
65, 69.
Three matters.
70.
Just now, half an hour back, I had forgotten.
Yeah, okay.
অভিষেক প্রসাদ আমায় বললো আমার জুনিয়র থাকবে আমি বললাম, নেই। And he said, but he has received personal service. He said, give it to me.
I'll impose cost.
Enough.
না না সব অর্ডার
No further wait, then it is to be adjourned for the day.
For the day.
Not today.
Not today. Not today. কালকে
Not today.
প্রাইমারি
On Tuesday.
NM1 P লিখে দিয়ে যেন দেয় আমার।
Monday, secondary matters are taken up. Yes, not today.
Item number
From other side. Then Passover matter 69 perhaps.
item number 69.
Yes. Not today.
এটা একই সাথে
Not today.
ওর মধ্যে একসাথে রেখে দেয়।
মানে
Item number 72. এটা not today. It is
72 same district, Malda. He appears in other matters.
Personally informed me.
item number 74.
Not today. Not today. Simply not today.
74 or not.
PSC no there
74. 74, yes. Who is appearing for the petitioner? 74.
Rabiul Islam.
74. Who is appearing for the petitioner? Yes, yes. Not today. Not today. Not today.
এটাও দিয়ে দে।
No, not today.
Item number 76.
Not today. Call 78.
Item number 78.
Yes. Who is appearing for the respondents?
We have served.
When you have served. Take it up when you have served upon the state. Have you served upon the office of the learned commentator? Are you aware of who is appearing for the state? So why you have not served upon other parties, only upon the office of the government leader? But that is not the correct service. In addition to effecting service upon the respondents, if state is party, you have to serve upon the state respondents, upon the office of the learned government. What you are praying for?
For to revert back of status from para teacher to
73 order pass.
Then who is appearing for Poshimbango Sarvashikha Mission?
Order pass. 77 order pass.
Yes.
order number 4.
Yes, Poshimbango Rajya Shikha Shishu, Mr. Sarwar Jahan appears on behalf.
Informed before they give.
Have you served notice upon him? No. No. They are the main party.
Order pass.
But there was no notice upon Sarvashikha Mission. You should take back this affidavit of service. At the time of call, no one appears for the petition, respondents, and no accommodation is paid. Learned advocate representing the petitioner is directed to serve notice upon all the respondents or the learned advocates representing the respondents by 10 days from date, enclosing copy of this order, and file affidavit of service on the next date. List the matter under the same heading on 21st July 2025.
Similar to
Just a minute. Let the matters be called on serially.
Item number 79.
and I put the petitioner. At least Mala not even complete Mala. Immediate service has not been ready.
Monthly.
Good, sir.
One of the I have one said for service or the immediate service.
Affidavit at the time of call, learned advocate representing the petitioner has paid for accommodation to complete service of notice upon the respondents. Stop. Let service of notice upon the respondents be made complete by 10 days from date, and affidavit of service to be filed on the next date. This the matter under the same heading on 21st July 2025. Next.
Item number 80.
Time for the statement. Sarvashikha Mission. Service is not complete. But where is your notice? এই শোনো তো এই ম্যাটারটা কবে ফিক্স করলাম ওই ছেলেটা অমিত কত পশ্চিমবঙ্গ রাজ্য শিশু শিক্ষা মিশন being respondent numbers 4 and 5 are not represented. Stop. Learned advocate for the petitioner is directed to serve notice upon respondent numbers 4 and 5 by 7 days from date and file affidavit of service on the next date. However, state respond next paragraph. List the matter under the same heading on 21st July 2025. অমিত ওই যে
One.
That was the state respondent.
Same order as in 80.
Amit.
Item number 82.
But I am having all the state respondent.
21st July, you have purchased 625.
The court will accommodate if there is circumstances which is beyond control of the members of the bar, court will accommodate. You need not be worried. No, I am not. At the time of call, no one appears for the petitioner and no accommodation is prayed for. However, state respondents are represented by learned advocate. Writ petition stands dismissed for default. Parties to act on the server copy.
Item number 83.
In mutual transfer, there is no bar of 5 years.
नाम की दिवन है
2 years confirm.
Confirmed teacher, both are confirmed teachers.
21 joining.
When you have applied?
Apply January 30.
January 13. Which page?
Page number 29. Now pending before the
Online application or it is application by email letter? No, it is pending before whom?
31.
The mutual transfer application is decided by the
Secretary of the board.
secretary of the board.
Yes.
It is routed
Through the chairman.
Yes, sir.
If it is pending, Mr. Shah, whether it is pending before the chairman of the council,
Yes, 34 page.
page 34.
Forwarded to the
So it is already forwarded to the West Bengal Board of Primary Education
সেটা একটা ডিস্ট্রিক্ট হলো
on 27 January. Come to page 34, Mr. Vishal.
Yes, I am on 34.
Yes.
But it is probably malad by one district. From the both of the district malad, it has to be malad reached to the malad. Malad, I tell you, Lordship malad, there was some.
If teachers are working in two different schools situated in the same district, then it is
Then
decided
not
by the
both.
chairman.
Chair.
So what is the case?
Different
Whether
district.
both the schools are schools situated in the same district or different districts? Different district. Petitioner number working in a school in which district?
One is primary school under Purulia district primary school.
Second is by the folder.
Then
It is by the board.
it is to be decided by the board.
Absolutely. Absolutely.
So it has been forwarded to the board.
Malad, I tell you, Lordship, malad, one. Malad, both the end of the both the district malad has to be come to the board. One district probably has come 34.
From which district it has come?
Malad, he is referring 31 also.
DPSC also sends the secretary of the board of finance. And also Kolkata DPSC.
Page 34 is from Purulia district or Kolkata. Where from you are getting that it is from Kolkata DPSC? Page 34. There is no-
Application number is written, Your Lordship, 5019321183. It has to
That
be
is in relation to Kolkata. Two separate applications are made by two teachers.
two teachers. That
One is at page 31.
Through portal. Now the application number connects the district. And another is
31, page 31. And you took my look.
this is from Purulia. So let
83. 83 page 34, 83. Application number. Probably malad, this is Purulia.
And also online application.
so both the applications have been forwarded to the
Has to be forwarded to the board.
secretary of the board.
Has to be forwarded to the board. Both.
No, it has been forwarded as
My lord,
it appears
I have-
from
I have
page
seen-
34.
34 I have seen.
183. Then page 31.
183 Kolkata. forwarded to DPSC.
83 এটাই তো 83
Has been forwarded to DPSC Kolkata. Has been forwarded to DPSC.
হ্যাঁ মানে page 33 has been forwarded to Kolkata DPSC not board.
Your application number has been forwarded to DPSC.
Then 34
34 is
34 is one district.
2183.
Yes.
2183 is from Kolkata.
Yes, 2183 from Kolkata.
Yes. What about Purulia?
31 এ তো মিল একটা গো।
Yes, Purulia.
But this is in connection with same application.
করা আছে। উচ্চশ্রী থেকে
একটা এসছে আরেকটা আসেনি না
ঠিক আছে।
But application ID is same.
DPSC তে আছে।
ID is same because of that one candidate.
No, whether the issue is pending before the secretary district board or it is pending before the Purulia district primary school council.
Board. February 21, 2025.
Find it out. Mr. Vishwas. Well, let me direct the secretary of the board to take decision if necessary. The DPSC Purulia shall provide necessary. Yes. Affidavit of service filed on behalf of the petitioner is taken on record. Petitioners is taken on record. Next paragraph. Both the petitioners are working as primary teacher in
এই চিঠিটা আমি বলেছিলাম দীপাকে একটা ব্যাগে
respective
রাখতে
primary
আজকে দেখাবো
schools situate in
মিউচুয়াল
two
ট্রান্সফার
different districts. Stop. Petitioner is number 1 is in Kolkata.
Number 1 is. Number 1 is.
Petitioner number 1 is working in a school in Purulia, whereas petitioner number 2 is working in a school in Kolkata.
আমাকে দে আমি দেখে নিচ্ছি।
No, one to Kolkata.
Malad, this is the latest letter. Just Malad, since your lordship is Malad dealing, Malad, your lordship kindly Malad, this is a that is why probably Malad all the applications are not considered. So, letter by the government.
Yes.
This is the Malad, that is the Malad, latest Malad
Situation.
and we are doing Malad considering. May I take your lordship Malad shortly Malad. Yeah.
Application was made before the concerned respondent authorities seeking transfer or seeking mutual transfer. which according to the petitioner is pending before the Secretary West Bengal Board of Primary Education for consideration. So, in support of such submission, reliance is placed on the documents at page 30, at page 31, at page 31 and 34 of the writ petition. State respondents, DPSC is represented. District Primary School Councils, Purulia and Kolkata are represented. Kolkata and West Bengal Board of Primary Education are represented by learned advocates. Next slide. Since application seeking mutual transfer is pending, and it is submitted by the learned advocate that both the petitioners are approved, are confirmed primary teacher, comma, Secretary West Bengal Board of Primary Education being respondent 4 is directed to take decision on mutual transfer application of the petitioners by 6 weeks from the date of communication of this order. While taking decision, if respondent number 4 finds it is necessary to consider certain documents which are required to be furnished by District Primary School Council Kolkata and District Primary School Council Purulia, those chairmen of those district primary school councils are directed to cooperate with the respondent number 4 for taking decision within the time stipulated by this court. So, decision to be taken by respondent number 4 shall be communicated to the petitioners by fortnight thereafter. Next paragraph, writ petition stands disposed of urgent xerox agreement. উপরে affidavit of service করে দিলাম। Next, yes, documents filed in support of depositing deficit court fee. Yes.
My lord, may I interest for a moment in item number 78, my lord?
No, this has been adjourned. It will appear on 21. 78, yes. Next matter.
Item number 84.
For the street, for the board loss.
Page 20.
From same district or different districts? This is for you, not for me. I have not called for any report. You are representing state. State has no role to play. You read it, and if it's necessary, you apprise this. Yes. When you made application? Page 20. 22. But page 20 is mutual transfer accepted details.
Yes.
Where from court will get it that it is pending before the district West Bengal Board of Primary Education? Yes. West Bengal Board of Primary Education. Come to page 20, Mr. Chaudhuri.
20.
Yes. Next chapter 4.
Asif, this is in respect of one candidate and 21 request sent to lordship.
That is in respect
Status.
of one petitioner.
No,
perhaps Pratima Rana.
Page 21 is there, lordship.
Page 20 and 21. Yes.
Status. Same.
So it is pending before the West Bengal Board of Primary.
Similar order may pass.
Yes. File your affidavit service and deficit court fee document. Affidavit of service filed on behalf of the petitioners is taken on record. Stop. Document is filed in support of depositing deposit court fee. Next paragraph. Petitioners are, what are the districts? Petitioner number 1, working in which district? Howrah. And petitioner number 2? আচ্ছা কি বলছিলাম বলো তো আচ্ছা petitioners are working as primary teachers in two different as primary teachers in their respective schools situate in two different districts. Petitioner number 1 is working in a primary school in Howrah, whereas petitioner number 2 is working in a school in Poschim Medinipur. It is submitted that both the petitioners are confirmed primary teacher, and they have applied for and they have made application seeking mutual transfer. So grievance of the petitioner is though application is pending before the Secretary West Bengal Board of Primary Education, being respondent number 4, but till date no decision is taken. Next paragraph. District Primary School Council Poschim Medinipur and District Primary School Council Howrah are represented by learned advocates. Stop. West Bengal Board of Primary Education is also West Bengal Board of Primary Education and state respondents are also represented. Next paragraph. It is next paragraph on consideration of the submissions made on behalf of the parties and taking note of the documents at pages 20 and 21. It appears that mutual transfer application of the petitioners are pending before the respondent number 4. Stop. Hence, respondent number 4 is directed to take decision on mutual transfer application of the petitioners in accordance with law by 6 weeks from the date of communication of this order, and the decision shall be communicated to the parties by fortnight thereafter. Next paragraph. Writ petition stands disposed of. Mutual transfer application portal is alive.
Lordship.
Next.
Item number 85.
Disputed question with regard to TET 2022, while our issue is pending before the division bench.
TET 2024.
TET 2022, my lord.
Have I passed any order?
Lordship has decided.
This is my payment of deficit court fees and affidavit of service.
ভিতরে যে পেন্ডিং আছে কমিটি পাস শেষ হয়নি, কমিটির লোক পড়াতে হবে, সেইটা পড়াবে, কাজ শেষ করবে, তারপরে গাড়ি চলে আটা বেঞ্চ যেহেতু বসছে, আটা বেঞ্চ যেহেতু সবাই বসছে, বেঞ্চটা কম হচ্ছে।
So that can is pending. Can 24.
Can was hard, my lord. Last week, my lord, tomorrow it was fixed, but tomorrow. Last week it was hard, my lord, by the division bench.
Now, with regard to TET 2022, which is the relevant can?
That is can 24, Lordship.
Can 24.
Which is the relevant MAT?
MAT.
Because there are 3 intra-court appeals.
Mat 917, তাই তো?
One is in connection with
Lordship.
TAT, TAT.
2017 and one.
2017 and TAT 2022.
Lordship.
So which one is
917, Mat
917?
917.
নামটা বলো না, নামটা কি?
Moshana Mitra যে can.
Yes,
মৌসুনা is 2022 Lordship.
that is in connection with 2020.
মৌসুনা মিত্র। ওটা হয়েছে ইয়াসমিনের সাথে।
Mhm, 917.
It is annex Lordship.
It is already annexed to that.
Page 119.
Same order. এই এটাকে দেখে করে দেবে। কারেকশন আছে, কারেকশন গুলো দেখে নিতে। না না,
Paid the deficit court fees, madam.
yes.
Out of list.
Out of
Item number 86.
I am for the petition.
I'm appealing the state respondent.
Petitioner was appointed in the year 2006, then were transferred to in 2010 some other school. In
appointed in 2006.
Yes, and 2000
When appointed 2006.
and transferred in 2010 by the school council. No problem. But due to my father's illness, father is 100% blind. That is why there is a mutual transfer. Kindly come to.
But once petitioner is transferred, whether petitioner can be mutually transferred.
Yes, that was granted. Your lordship, kindly come to page 23. Yes, kindly come to.
Kindly come to page 23.
Yes.
Page 23, my lord, individual local adjustment.
But after one that this is not some transfer by the council, this is a mutual transfer and mutual at the page 23 with the approval of the council. Kindly allow me.
No, no, I am asking him, that's why he is replying, giving reply.
Because both the school, the private respondent and petitioner are relating to the nearest school. By your,
But you are paying.
but now after 7 years, 8 years left,
This is the letter order dated 6th April 2017, passed in your case.
no problem.
Passed in your case.
Yes, both private respondent and mine. Kindly see Shubhankar, Shankar Subra Banerjee and Prabhat Sarikar. Both. With the consent of the both. And that was with the approval of the council.
So there was interchanging of school
Yes.
amongst two teachers.
There is both consent. Now, Milo, all of a sudden, after lapse of about 8 years, issue the next page, page 24.
Yes.
On the basis of the recommendation of Village Education Committee, because there is an allegation against the private respondent, that is why I have been asked to go there. And that was without approval.
That's
রিজিগনেশন করা নাই পেজে ঠিক মতো 30 32 কত আছে পিটিশন
Well, how the SI can withdraw? This was a first letter that was approval of the council. Now SI withdraw and cancel.
local arrangement.
Now you are working where now?
And now I am still in Virampur High School. And after this order, the private student join here. I have been asked to go to the Katadorja High School, private school. Well, the next period, against that primary, our VEC submitted the prayer before the authority not to transfer the petitioner. Well, the private student transfer on the basis of the some allegation against him.
So now you are working in Obirampur Primary School.
Yes.
Okay, another teacher is working in Kantaraja.
Now he was allowed to join here. By
Now again the arrangement or what was the position prior to 6th of April 2017 order that has been revived.
Revived.
Yes.
Revived. But where is the difficulty?
Difficulty
Because
that
it was the original arrangement.
but the difficulty
It was mutual local adjustment.
But kindly consider this. Now I have to go to 25 kilometers that school, and
But you were working there.
that is why mutual. But
No,
kindly
there was a
mutual
mutual
transfer.
local arrangement. You were
No,
working.
mutual by consent, both by consent of the both.
No, issue is this that there is no application made.
Yes, yes. On the
Previously
basis
on
of the
6th of
application. On the basis of the application.
Which order was passed?
Both kindly see
6th April 2017
yes,
order.
that is why the council approved it.
No, I am asking you 6th April 2017
Yes,
order.
kindly
6th April 2017 order.
Unless
Please,
taken up-
please allow this court to
Yes.
post certain query to you.
Yes.
A memo dated 6th April 2017 order was based on your application, mutual
Both
transfer
joint
application.
application. Joint application.
Where are those applications?
But that I have not done, but this has reflected from the order. That is why council.
There you file this file a supplementary affidavit.
Yes.
Bring on record. those
Well, in the meantime, not to allow me to go to.
In the meantime, nothing.
But
Because this order was passed on 26 December
wrong way.
2024.
No. Thereafter, last order, kindly see. That is why the next order, kindly see. That is on 9th of June. Immediately I filed this. Kindly come to me on page 7. No, not page 7.
Page 7.
No, page 7. That is page 42.
Annex
42,
37.
not 42. Kindly come to page 45. That is 4th of June. And that was served on 9th of June. I filed this on Thursday, mention it, my lord, before on Monday, your lordship.
But this order has been passed by the chairman, District Primary School Council, not by the sub-inspector of
Well,
school.
well, how that can be on the consent of the private respondent? Well,
Mutual arrangement.
Well,
At any point
by
of
both
time, it
consent.
can be, my lord, the originally it
No,
was,
but
it
if
can be
the
done, my lord.
party is submitting that that
My lord.
Mutual transfer for the both by the
that first order in 2017
Lordship.
was issued based on mutual transfer application.
Yes.
My lord,
So if
I
you
have,
by
my lord,
mutual transfer application, but
My lord-
if mutual arrangement is made instead of
Yes.
mutual transfer,
at any time
come
it can be done.
come to page,
Yes, I have
just
said-
a minute, come to page 23.
Yes.
It's a mutual local adjustment.
Yes.
Now mutual local adjustment,
He has
you
to
have
go to
accepted it.
the,
Well,
You have
even
not-
then,
You have
after-
not made any application seeking clarification before the chairman, District Primary School Council, that mutual local
Yes, I have
arrangement was-
also made a prayer that I have not annexed. I have
if that was not corrected, then you ought to have
that is
taken
why I
legal
made a
steps.
prayer in 2019 also.
So by efflux of time, it appears that this order for mutual local adjustment was accepted by the petitioner.
Well, kindly come to the page.
Now your
Yes.
learned friend, your learned advocate representing District Primary School Council is submitting that if it is a case of mutual local adjustment, not mutual transfer, then previous situation can be revived at
Well,
any time.
kindly, only by the private respondent. Kindly come to page 24. Please, kindly come to page 24. As per prayer of Mr. Prabhat Fadikar, for a mutual consent, there is a both consent.
Page 24.
Both. The previous is both mutual. Now, as per PR of Prabhat Fadikar, assistant teacher of private schools, dated such and such. And
Mr.
at-
Saha, why this decision was taken?
My lord, I have to take.
Well, there is an allegation against the
No,
private
no,
school.
second.
Not only that,
Yet-
but after filing the
What allegation?
allegation, there is some that was not have your lordship. That
What is the allegation?
well, allegation, some other things that I have not collected because they have not supplied me. Otherwise, the issue, why the issue take?
So,
My lord, let me come with the
File a
instruction.
report.
File a report.
That why this
Yes,
order
my-
was passed.
My lord. I shall-
Unsettling the settled position as it was effected video order dated order dated 6th April 2017.
Lordship, but my lord,
After such a long time.
lordship, my lord, at any, because of that,
After 8 years.
Yes.
because of that, my lord,
Why this has been done?
this is to be done at any point of time. Because of that, his service, my lord, what service related documents, it is lying with the main school, my lord,
8 years.
where he joined, from where he has come to the mutual arrangement school, my lord. Therefore, my lord, it is ought to be done by the authorities before that local
Where is the
arrangement should
provision?
be. My lord, I shall come with all, my lord,
If there is an
Lordship.
order of mutual local
arrangement, it can be
then the previous
revived at
situation
any
can
point.
be restored.
My lord,
Previous situation relating to posting of these teachers can
just
be restored.
restored.
Where is the provision?
My lord, I shall come.
Well, next,
Kindly,
well, after filing this,
Sir,
there is
next-
another arrangement below. Now, petitioner, the private student joined in my place, and another teacher submitted mutual transfer on portal. And then the private student again go to some other.
My lord,
school
all these
nearer
things, my
to
lord.
his residence. I
My lord, all
mentioned
this-
them. Who is that person?
The private
Shaktiman.
student has already joined the post where you are asking. What
Yes.
Then
Then I have not been released. I have been still there. Now I have not been allowed to sign the attendance register.
My lord, kindly.
why you are coming such?
No, I filed my online.
No. This order was first order was passed on 26
No,
December.
there is no.
2024.
Then again.
Then you did not take
Join.
any legal
That
step.
is why they.
Then ultimately, when the another teacher joined your post,
No.
then
Prior to
4th
that,
of June 2025 is the second order.
No. Prior to that, there is a hearing by the chairman. Kindly come to page 44. I've been asked to appear for hearing. Then the next order.
My lord, kindly come to a, my lord, kindly.
24.
Oh, 44. I've been asked to call for a hearing before the chairman. When I took the point, when the transfer issued on mutual consent.
Then
by
after
the-
hearing, which order was passed?
Nothing order, no communication.
My lord, I have to.
Then straightway they have issued the transfer.
Hmm.
When another incumbent joined your post,
After this order,
which order?
what the page 45? Perhaps on 11th of Monday last. Monday last.
So then that person has to be added as
Yes.
party.
Yes, I have made party. I have soft copy.
Served upon him.
Yes.
When he has received it.
Well, on 18. Hey, no, 18. Well, this is the last annexure I'll see.
My lord, let me come with a, my lord, report, my lord, from the chairman of the TPSC, my lord. Fix a date, my lord. On that date, your lordship,
Then I have
it
issued
already.
a notice. And why I have been not placed under suspension? I have been allowed the
Why?
mutual transfer because my father is 100% blind.
In that, even you ought to have made the petition in the month of January.
Teacher who is near to
When
resident,
this order was passed
now
on
he will come
25
kilometers again.
26 December 2024, when the order was passed by the.
That order
by
is bad
cancelling
because
that.
the transfer are
Let
issued
me
by
come with all these things. I have to come with. You have
Yes.
submitted your case, but I have to come with the facts and circumstances and the order passed, which is what is the order,
on the
everything.
basis of
And
their VC. He has
my lord will
allowed
hear
to
out the
transfer.
matter.
Our VC also take a resolution and requested the chairman not to take any step.
Why not to take any step? If these steps have been taken. I shall come. If it is unlawful, then it ought to be, it must be decided by this honorable court. But this is not the thing.
No, the hearing took place on 22nd April.
Yes.
And this is the outcome of hearing, that is 4th June 2025.
Yes. That was served on 9. I filed the petition on 11. I mentioned.
I shall come with that order also, my lord.
But what is the reason?
I don't know, my lord. Actually, I have to take because of that.
Where is the reason in page 45?
My lord, I shall come within, my lord.
Here
Yes.
See, the order is a cryptic order.
কিন্তু এটার কপি তো এর মধ্যে সবটা নেই তো।
কে বলেছে আপনাকে এন্টার কপি দিয়েছে? এই যে দেখো।
Please come to page 45.
45, my lord.
Don't try to wrap up the.
No, my lord. I shall not.
Page 45.
Yes, my lord. সংসদ প্রেরিত প্রত্যঙ্গ স্বাধীনতার তারিখে শুনানির জন্য 3 দিবসের মধ্যে আপনাকে।
It's an unilateral direction. Where is the reasoning that why this present situation should be the situation which was there prior to 2017 should be restored?
My lord, kindly, my lord.
No, I'll stay this. The private respondent has to go back to his own to the school where he was working.
My lord, kindly fix it on Monday,
Yes,
Tuesday. My lord, I shall come with the, my lord.
I'm not at all satisfied with the
my lord,
order passed on 4th June 2025.
My lord, I am coming with this, that, my lord, orders, my lord. Kindly fix it on Monday, my lord. I shall come with everything.
So, affidavit of
Yes,
filed on behalf of the petitioner is taken on record.
Kindly fix it on.
In spite of service of notice upon one Prabhat Fadikar being respondent number 7, he is not represented today. Next paragraph. Petitioner and respondent number 7 were working
Atadorja and Abhirampur Primary School.
In
petition in Abhirampur and private school in Atadorja.
Abhirampur,
yes,
primary school, and the Kanta Daraja primary school,
yes,
respectively, in terms of memo dated 6th April 2017, issued by Sub-Inspector of Schools, Narajol 2 Circle, Paschim Medinipur. Suddenly, an order was passed by the concerned Sub-Inspector of Schools on 26 December 2024. Order dated, কি বললাম suddenly এটা বলো তো? Withdrawing previous order dated 6th April 2017, thereby directing petitioner and respondent number 7 to go back to their previous schools. Stop. However,
that too without permission of the
however, this order dated 26 December 2024 of Sub-Inspector of Schools, of concerned Sub-Inspector of Schools, was not given effect to. Subsequently, a notice was issued by the chairman, Paschim Medinipur District Primary School Council on 9th April 2025 to the petitioner, thereby fixing date of hearing on 22nd April 2025. The petitioner appeared before the chairman, District Primary School Council, Paschim Medinipur on 22nd April 2025, and thereafter a cryptic order was passed on 4th June 2025, directing the petitioner to join
primary school.
Kata Daroja Primary School within 3 working days. Stop. It is submitted by Mr. Maithil, an advocate representing the petitioner, that impugned order dated 4th June 2025 was received by the petitioner on 9 June 2025, and thereafter writ petition has been instituted. Writ petition was instituted on 12 June 2025. Next paragraph.
I have filed on 9th of June or perhaps at 11th of June filed.
No. Next paragraph. On Anna. At first blush, it appears that impugned order dated 4th June 2025 passed by Secretary, District Primary School Council, Paschim Medinipur, is unreasoned one. Stop. Learned advocate representing District Primary School Council, Paschim Medinipur, has prayed for accommodation to obtain instructions. Next paragraph. District Primary Secretary, District Primary School Council, Paschim Medinipur, is directed to file a report in the form of affidavit disclosing why petitioner was sent back to Kata Daroja Primary School. Stop. Copy. Stop. Leave is granted to the petitioner to file supplementary affidavit in order to bring on record applications made by the petitioner and respondent number 7 seeking mutual transfer, based on which order dated 6th April 2017 was passed by the concerned Sub-Inspector of Schools. Stop. Such supplementary affidavit to be filed by 7 days from date.
By 10 days, because to
Stop. Next paragraph. List the matter under the same heading for further consideration on July 2025.
Yes.
Stop. Next paragraph. Impugned order dated 7 June 2025 issued by Secretary, District Primary School Council, Paschim Medinipur, shall remain stayed till 31st July 2025 or until further order.
Proceed.
All the fixed matter.
TPM fixed matter item number 349.
First, I will get try to get clarification from you. So for certain gray area is concerned.
Lord, in this matter, my Lord, I am appealing for respondent number 3, Central Vigilance Commission. I have to make submission for 5 minutes. Can we go to
So, if, Mr. Mojumdar, sit for 5 minutes because you are to give reply.
Central
Before
Vigilance
that, as per system, he should.
Yes. There's nothing. What's it? So far, Central Vigilance Commission is concerned, my Lord.
Yes.
Actually, there is no relief against them, and there cannot be any.
Yeah.
There cannot be any relief against them.
There cannot be any
Relief
relief.
against the central vigilance. So if some complaint is made, they'll make inquiries, appoint somebody and give a report. And thereafter they advise. So it is in the advisory capacity. My lord.
I have one question to you.
Yes.
That in terms of the order passed in the previous writ petition of 2009
Yes.
and subsequent order passed by the Honorable Division Bench on 13th March 2013,
Yes.
why a responsible officer of CBC was not present at the time of scrutiny, or in order to find out who were the eligible candidates to be given appointment on compassionate ground?
My lord, he applied for exemption and exemption was granted by the court.
Which exemption?
Exemption for not appearing on that date. Not in the
But
presence of.
subsequently also there was an order by the Honorable Division Bench on 13 March 2013.
Lord, they have complied.
Only extended the time for a period of 6 months.
Yes.
Mr. Mojumdar, in terms of that order also there was necessity so far necessity to represent CBC at the time of scrutiny.
For day-to-day supervision, it was modified to the requirement of CBC.
As per requirement of CBC. So what was the steps taken by CBC?
But after inquiry,
What was the
because
steps taken by CBC?
after making inquiry, they found them guilty. They found them that they should be punished rather, and they were punished.
That the officials of
Officials of
GRSC.
GRSC.
But what about the fate of the petitioners who were seeking appointment, who were in the frozen panel of
For that, the
31st March
advice is there.
2006?
For that, Central Vigilance Committee has advised. That
Yes.
advice they have to follow. The government has to follow. They have given the advice also. And actually, they have given the advice, they are in the advisory capacity. In the act itself says. And again, in the act it says that they should not be made a party. Here they have made a party, Central Vigilance. They are not at all a necessary party. The act itself says, that no proceedings shall lie against them. But kindly see, Article 15,
Yes, you are what you are submitting, which provision you are relying upon?
15, section 15.
Section 15 of which act?
This Central Vigilance Act.
Yes.
Right. This clearly says, my lord, may I read it? My lord? No suit, prosecution, or other legal proceeding shall lie against the commission, the Central Vigilance Commissioner, any Vigilance Commissioner, Secretary, or against any state of the commission in respect to anything which is in good faith done or intended to be done under this act.
But does it debar the petitioners to pursue their remedy for getting appointment on compassionate ground?
Well, that they can find, the parties are there.
There is no.
I guess
Grievances against the GRSC.
They have the grievance against GRSC.
Raised objection against the mode of recruitment under compassionate
Yes,
ground.
that is correct. But there is no grievance.
Taken care of by the court. New scheme was framed. And whether petitioner is to be considered under a new scheme or the scheme which was previously
That's up to them.
Considered by this court.
Yes, yes.
But to that extent, Section 14 does not impose any
50.
fetters.
That is between them, my lord. So far, Vigilance Commission is concerned, no suit of proceeding lying against them, because actually there is no relief.
Any other submission?
No, this is only something, because Central Vigilance has nothing to do now in this case. And they are in the advisory capacity.
Yes, take your.
They will not file their affidavit in Supreme Court also, which must be a part of these Supreme Court records.
Yes. Yes, Mr. Majumdar,
Yeah, that. Yes.
take back this. এই এটা দিয়ে দাও ওনাকে। কাম টু পেজ, এটা দাও তো, সেকেন্ড প্যারাগ্রাফ, পার্ট 2 টা দাও, এসএলপি এটা। Come to page 658, part 2, SLP. You are on page 658. Now, from this letter of the union dated 31st May 2024, when an exercise was carried out in terms of order dated 20th May 2024, passed in MAT 850 of 2022, it was admitted by the union that out of 49 petitioners, 30 submitted their documents. So what about rest of the 19?
All had submitted their documents earlier. A vigorous objection was made by the learned counsel appearing for GRAC that a fresh process should be undertaken in a new laid down permission procedure. The Honorable Division Bench expressly said no. You have to follow the same process of verification as done in earlier cases.
So therefore, in earlier cases also, for making and completing an exercise, whatever documents which were filed in 2006, these were required to be filed by the 19 other candidates.
Those penalties are
but these were not submitted as it admitted by the union.
All 49 were submitted in the previous round. Otherwise, they could not have rejected.
Yes, but when the order was passed by the division bench on 20th May 2024,
yes,
then there was a request to submit those documents. But these documents were submitted by 30 out of 49.
Yes.
So if to the extent of this 19 candidates, how this exercise can be carried out?
This was done. Please see. Current financial condition certificates in original for 30 candidates out of 49 as issued by the local councillors, gazetted officer or Pradhan Panchayat, full stop. So 30 in respect of those who have issued, these are 30, then full stop. Income certificates of rest of
appellants. Read the entire sentence. All the individual persons appellants had submitted such certificates, and after ascertainment of financial condition, they were allowed to participate in the recruitment process at 4th phase. Very well. Be that as it may, the union is forwarding the current financial condition certificates in original of 30 appellants.
Yes, please see the next sentence. Income
30 appellant names are given below.
Yes.
Out of 49 appellants as issued by the local councillor, MLA, gazetted officer, Pradhan or of Gram Panchayat, income certificate of rest of the appellants
will be forwarded immediately after getting
the same. Please note when these were forwarded.
But this was, if required, you may also specify a date and time at the earliest for inspection and verification of the respective bank accounts in presence of 3 officials of the union, namely Sri so and so. The entire process of bank account statement verification may be videographed by you, and a CD may be handed over to the union's representative present at the time of verification.
And in the table, it has been shown that only 30 candidates
30 as certified by them. The rest were in the process.
Therefore, is there any scope left to consider the case of rest of the 19 candidates?
But we said that please give us some time. In the meantime, you carry on with the scrutiny exercise. That's the purport of this letter.
No. Union specifically submitted that stated in the letter that out of 49 appellants as issued by the local councillor so and so, income certificate of rest of the appellants will be forwarded to you immediately after getting the same.
Yes.
So when these certificates or these documents were submitted on behalf of the rest of the 19 candidates?
Has not been so far. These are ready. Once the process commences, we will immediately handing over. These are all ready. We can produce it before your lordships also. Since the Honorable Division Bench's order was not further carried forward, or they did not act further on the basis of this to the communication of the union, therefore those are not handed over. But we have gone to the extent of scrutiny of bank accounts even.
So then in that event that this process has to be carried out by the concerned authority of GRSC on submission of documents.
That the honorable division bench desired that since long time has elapsed, why should the court not look into the present?
Let us go back to the order of the honorable division bench. Just a minute. Is additional document by union, Mr. Mojumdar. Please come.
That
Corrected order.
page 9 and page 10 of the IE.
Yes, page 9. Respondent shall, it should be the appellants.
Appellant. The respondent shall in the meantime ascertain the financial condition of the
It
appellant.
could be appellant. Appellant shall in the meantime ascertain the, because it was corrected subsequently.
Subsequently.
Meantime ascertain the financial condition of the appellants following the decision taken earlier in this regard. Now, following the decision taken earlier in this regard.
Yes.
Yes.
Taken earlier.
So, if following the decision taken earlier in this regard, so division bench permitted the GRSC to undergo fresh scrutiny.
Fresh scrutiny.
Fresh scrutiny.
Following the decision taken earlier. So the whatever was earlier prevailing, so that would be prevailing. That was the understanding. This was thought to be corrected. Now, not what was the nature of correction?
Now, according to what was the earlier situation?
Not that penury certificate from not the same manner in which the other persons had submitted.
Very well, but for that submission of fresh documents are required to be
We
made.
had submitted 19 or 18 were left. There are 49 petitioners. One is a trade union. 18 were left. But we were ready to hand
But
over.
one thing that is also troubling this court, if today court directs GRSC, a concerned authority of the GRSC, to complete the exercise and find out the eligibility in terms of indigence, in that event, whether in terms of 2013's, whether that can be carried out in terms of 2006 scheme in view of the law laid down by the Supreme Court.
Financial penury would not depend on any policy. Financial penury would depend on not what is the situation of a hand-to-mouth situation today and what the family is earning. That does not depend on any policy. Not the policy was.
No, but the financial condition, what is the financial condition or what is the hardship which make a candidate eligible to seek appointment on compassionate ground? That eligibility criteria is laid down differently in two different schemes, one in 2006 and another in 2013.
2006 in my submission, in my most respectful submission is stricter. It said
indigence.
If any member works, no application to be entertained. 2013, that also took into consideration financial indigence. This also has taken into consideration the same aspect. Today the situation would be what is the possible earning of a member of a family who is earning in this, who is working in this capacity, and what is the income generation of the family. That is the test of indigence, and that will change from time to time. What was minimum wages in 2013 is certainly not the minimum wages in 2025.
Yes.
And that chart was before the honorable division bench. That central government rates of minimum rates of wages. GRSC pays 150 rupees more than the daily rates of wages that prescribed by the central government. So a daily worker probably earning 750 to 800 or 850 rupees depending on the categories on an average. So 26 days a month, that's the earning of a worker in the unskilled category. What is the earning of the family?
Therefore, then these 19 petitioners are required to be submit their documents.
Of course.
Based on which financial hardship or indigence is to be.
We did not oppose this exercise to be undertaken. We did not say that let the 2013 situation be continued. We did not say so. And therefore, we volunteered to say, please get it videographed. You have the mechanism. Please examine the bank details. But keep our union member in presence. Otherwise, this may be again leading to some faulty exercise. There has to be identification. The management personnel may not be in a position to know who the family members are.
Just. So in that should be in terms of 2013 scheme.
2013 scheme does not.
Based on the list which was prepared in 2006.
2013 scheme says we have to undergo a financial, exercise of determining financial penalty. 2006 says
2013 exact terminology which has been used is indigence.
Indigence. Now 2006 says if anybody is working, then no application to be entertained. But I submitted, if your lordship kindly recollects, and I submitted if somebody is working in the family with an earning of 2000 rupees per month, then that applicant would be disentitled. So 2006 was stricter in that sense.
If any member of the family works.
To what extent? So
In terms of 2013 scheme. Then there is a related issue. এই সেলফিটা দাও।
Yes.
Come to page 222 SLP.
my lord.
Now this is 2013 scheme. Now if this fresh scrutiny is to be made after submitting documents in support of financial condition by 19 candidates along with 30 who have already submitted documents, then it is to be made in terms of 13 situation, which says that financial condition of the candidates will be determined on the basis of certificates from competent revenue authority.
Nobody knows who is the revenue authority. This was also
If
there
you come
previously.
to if you go back to page 658 of SLP2.
Yes. Local councillor, MLA, gazetted
Yes.
officer, Pradhan. No, please recollect not page 10 of the page 9 and 10 of the IA. In the honorable division bench was considered.
IA. Issue দেখুন। IA is there, rejoinder by GRC, but there is no.
There is a very thin compilation IA before the honorable Supreme Court. That is the additional documents.
Yes, additional documents. Page.
Nine.
Yes, what you are trying to submit?
The respondent shall in the meantime ascertain the financial condition of the applicants following the decision taken earlier in this regard. So not whatever was proceeded with in the earlier round, so you proceed accordingly in the earlier round. Whatever documents they have considered in the earlier round, consider those. This was done in this way, in the absence of an identified authority. Who is a competent revenue authority? Nobody would know.
And these documents in connection with 30 candidates which were submitted, this is as it already appears from page 658 that local councillor, MLA, gazetted officer
Has done in the earlier 3 phases. 170 have submitted like that from the panel of 279. We followed the same procedure.
And who is the revenue authority that has not
I don't
been
know who is a competent revenue
prescribed?
No. Nowhere it has been defined or identified.
that I want to consider 655 of SLB 2.
Just a minute.
655 of SLB 2. One of the DI
Just a minute. I will hear you. Yes, what you are submitting? 655.
One of the DI candidates applied to the company regarding revenue authority, and he has been totally described how to do, how to obtain. Please see, Dr. Kali concept 655. And if the other persons, if there is a difficulty, if they do not apply, then how can we come to know that they do not know anything?
Please read this with page
And
10 of the
Dr. Kali
interview.
consider another aspect.
Right out from the police station, who is the revenue authority? That's the stand of an employer.
Yes.
Employer does not.
I am guiding that. I am guiding that.
Right.
When one person has come to us, we have said this thing, and when others are not coming, that means they are in knowledge of the thing. This is one part.
Section
And
100,
subsequently consider
Section 114G of Evidence Act has to be rewritten then.
compassionate appointment, evidence that will apply, this is unheard of. And in nine EIH candidates have submitted their penury certificate, so it is not unknown to them, and it was there in conduct proceeding. So union cannot say that it is unknown to them.
I believe
Then-
that they have
then how can they
argued for 5 days. I am in reply.
And also kindly consider it is being repeatedly heard that union will certify. Not to kindly consider page 44 of the additional document submitted by DRC. This certification by
So therefore, according to you, this letter dated 10th October 2014 is to be complied with by obtaining the information from the local police station, who is the revenue authority, and the
it is not unknown to them. Nine persons have given. 9 persons have given. This is in the contempt proceedings. It was there. It is not there. And also kindly consider it is being harped upon time and again that union will certify. This certification has been deprecated. And what are the certification what you will find? Page 44 to 46. Page 44 to 46.
How it has been certified by the union? Additional documents of the years.
And the company promotes its officers.
And the company?
Promotes its officers. Just a back scratching and then promote them.
Displeasure.
Displeasure. And I've handed up those subsequent promotion orders.
And also kindly consider
All those
page
persons.
44 Page 44 to 46 of the additional documents submitted before the Supreme Court. This is the way the union has certified. And that has been deprecated.
By
That has been deprecated.
Deprecated by
The
the.
union cannot do it.
Who has deprecated? Who has deprecated? The persons who aren't displayed there.
Unions and union is now saying that they will identify everything when they give the particulars which is contrary to everything.
In 2006, when the scrutiny was made, that was based on the certificate issued by the MLA councillor.
Yes, yes. Door-to-door inspection carried out jointly by the management representative, union representative. Even in 2014, when that board decision was taken, how was the review committee desired to be constituted? 2 representatives from the union, 2 from the management.
No income certificate was given. No income certificate was obtained. No income, and that was the infirmity. It is mentioned by CBCMC and
All those strictures on model employers are not just going down the drain insofar as this employer is concerned.
I request my letter friend not to personalize the industry.
So, therefore, your contention is this: on submission of the documents by rest of the 19 candidates, the procedure to be followed in terms of 2006.
Yes. The Honorable Division has said, as you have done earlier.
So that has already been done, Lord Supreme consider.
Earlier would not be in 2013.
Lord Supreme consider.
In the absence of an identified authority, the order of the court cannot be frustrated. But I would go to the extent of saying that the company is trying to hoodwink this Honorable Court. Apropos the stand taken before the Honorable Single Bench in 2009 writ petition, carried up in appeal, the specific stand taken, everything is done fairly, transparently, and we want to comply. Now to take a completely...
That is in the affidavit.
In the affidavit. Now to take a contrary stand is really an abuse of the process of court. It's an abuse of the process of court, and the person who is taking such stand should be hauled up. Filing different affidavit, different stands before the court of law in 226 jurisdiction.
Take the trouble to consider.
Just a minute. I am hearing Mr. Mujumdar in reply, Mr. Dev. I have heard you.
That 19, your lordship is.
I have not curtailed your time.
No. What I am trying to, because your lordship is concentrating on 19, how to be done.
What are the gray area while considering the issue? I need to iron it out.
Lordship,
I need to iron out creases.
Absolutely, that has been done through 627. In 2014 exercise, 24 exercise, that has been done based on 2006 documents. That's why I am trying to show you for your lordship. That has been done 627 onwards.
What is the order passed in the contempt by the division bench presided by Justice Chelu?
482.
That's Page 482 counter.
Yes, there a point has been taken, Mr. Mujumdar,
My lord.
that it was found that there was no willful deliberate violation.
Willful deliberate.
And now a report has been referred to and it has been set out in the order. And it is submitted on behalf of GRAC that such report was not under challenge in this writ petition.
So that's my prayer. Set aside
Because
the rejected orders.
if you come to the last part of the order of the division bench,
Yes,
page 487,
my lord.
there is no consideration of the application in accordance with law. There is consideration of the application in accordance with law as understood by the committee as per the report from paragraph 14 onwards.
Since there is
Yes.
Since there is no intentional violation of the directions of this court, we are of the opinion that there cannot be any further action for contempt of court. Accordingly, proceedings are dropped. It is open to each individual to assail the decision of the committee if they desire so in accordance with
So
law.
very such.
That's my prayer. Set aside the rejection orders.
Let us go back to the prayer. Five and 17.
Appoint on compassionate ground to rescind, recall, revoke and withdraw the orders of rejection of your petitioner's candidature.
And except P20.
Yes, that was the communication.
So is P20 is the
Yes.
order which has been referred to in the.
I can challenge only whatever is communicated to me.
And so far the terminology indigence in 2013 scheme, indigence has not been defined anywhere in that scheme.
Not as in government service, as in the school education department, your lordship has seen. It says the government has now laid down a policy. If the income of the family, even after receipt of terminal dues, falls below 90% or probably it's 70% in the school education department, then it is a fit case for consideration. Indigence would not mean I am certain. In my, I beg your lordship.
Just a minute.
Lordship was writing down somewhere.
Yes, Mr. Modi.
What is indigence? Indigence is not defined within the parameters of any of the schemes. So, my lord, I cited two judgments when I had opened my argument. What would hand to mouth mean? Is it a bare animal existence or something more? That's why the minimum rates of wages came.
Yes, now you make your submission. These are the things I thought it is required to be elicited from you.
Right.
Yes.
Now, my lord, principally 6 or 7 points had been urged before your lordship. The first point is a restricted interference in policy decision and scope of judicial review. Two judgments had been cited in support thereof.
Yes.
And I submit that I am not challenging a policy decision before your lordship. I submit that please grant appointment to me following the policy which existed at the time of semi-finishing the exercise. We were already at the semi-final stage. Complete that. Why should I challenge any policy?
Yes, yes.
And 2013 policy is not a standalone or a crutchless policy. It can't stand alone.
That you have submitted.
Yes. Then not the second point are
Because there are certain provisions which depends upon earlier policy.
Yes. 2013 left alone can't be fructified. A concession once directed cannot continue. That was the second point. Or not a wrong cannot be allowed to continue. No, what is the wrong?
Negative equality.
But it's not a question of negative equality. Say if the company's argument has to be accepted,
Yes.
in fact, I'm grateful to my learned friend. When the Honorable Division Bench was hearing the matter, their Lordship's bench desired a rate of wages payable to the workers of the company presently. This was handed up to the Honorable Division Bench, not when the matter was heard, but my learned friends were also. That the central government notified minimum rates of wages, GRSE pays 150 rupees more on account of each grade. That's decided by way of settlements. Now, if this submission of the company has to be accepted, then not the respondents will be allowed to actually challenge their own action or order.
As well as 2006 scheme.
Respondents are challenging their own action or own order. This is never permissible.
Yes. Now, what about your submission with regard to the report of 3-member committee on financial condition? After submission of this 30 documents from 30 candidates, it is part of SLP part 2. Mr. De, where is that 3-member committee report?
The formation of committee.
After
conclusion.
After Honorable Justice Shomensen's bench. Oh, yes, that was
conclusion at page 622.
Please visualize the situation. On one hand, the company would say, you have not submitted penury certificate. I have shown you the local police station way back in 2014. Now they say, I have considered your case and rejected. But during the continuance of proceedings, varying stance or vacillating stance does not obviate our person's rights. Your lordships are considering this now. And when it comes to real consideration, they show me the police station. You go and ask for them. I don't know who the revenue authority is. The Honorable Division Bench has said, follow the same process as done earlier. So, this is not a case of negative equality. But next came the argument that the advertisement was for open category post and there was no reservation for compassionate appointment.
Yes.
Has your lordship not ever heard that a person claiming appointment under compassionate scheme is applying through a regular recruitment process?
No, that is not the
system normally.
System, yes.
There is a vacancy available, one is appointed against that group, class 3 and class 4. These are all workers, unskilled and semi-skilled categories. They will be trained up to semi-skilled and then skilled categories. Now, that's the stand taken in pages 94 to 95 of the counter. I had argued that. What was the stand taken on affidavit before this Honorable Court? How these persons are ultimately absorbed?
Yes.
And that they were given a preferential treatment in the recruitment process.
These candidates under DIH category.
Yes. And that's why 170 were appointed. from the panel of 279.
Yes, that there is a specific. Just a minute.
But in the three phases,
The tabular form it is given.
yes,
Just a minute. It's a documents, additional document by union,
I know,
page 58.
I know.
And there were certain candidates who were appointed under open category.
Yes.
Total number was 43 up to third phase.
Non-DIH appointed 13, 10, 20, 40.
Yes, yes.
So that they were given a preferential treatment, obviously, because of their policy, decision or agreement. And similar orders passed for other petitioners by this honorable court. Give them a preferential treatment.
Yes.
Then not comes the question of introduction of 5% vacancy reserved for the.
No, that is in that document also there is a recommendation to exempt to the 5%. Yeah, yes, that and this decision was taken on 31st of July 2014. Come to page 53, that I have seen. To that extent, Mr. They submitted that there was no approval by
board.
By the not by the board, by the central government. Page 62, paragraph 37.
The issue was
one-time exemption. You are to submit one-time exemption. That you have pointed out during course of this.
Now, the government says my guidelines don't apply to you.
Another, since you are taking the point of this 5%, because in terms of 2013 scheme vis-a-vis 1997 scheme
and the 2006
yes, 6 scheme, then it was that up to the extent of 5%, this appointment can be made under DIH category. Now, there was also another condition, that is training. They are also that training was those who are trained candidates, they are to be considered first as casual and then they are to be absorbed on substantive basis.
Please visualize the paradoxical situation. But who will be trained? Unless I enter the field, how will I be trained? They are the persons who are brought in service to the recruitment process, initially treated as trainees, then subsequently absorbed. But it's semantics. It's semantics. It's really playing with words. But I'll show to your lordship now. I've read that paragraph from the affidavit of GRAC. How they are the process of absorption.
First appointment, then training, and then substantive appointment.
But otherwise, not a compassionate appointment candidate. But what is the scope?
Is anything more?
Then not came that scope of tense of immediacy. Now, this is answered by paragraph 65. This is answered by paragraph 65. Sorry. There was an interim order passed by the Honorable Coordinate Bench by His Lordship Justice Dipankar Datta when he was adjourning this court at pages 581 to 582. Reserve the posts.
Yes. That interim order was there. Last occasion, I also. These posts are there. There is no alteration of position after the order passed by Justice Datta sitting Singh.
And not, in fact, the second Canara Bank judgment, 2025 judgment, this really supports the cause of the petitioners to the extent of holding that the time period taken for deciding the litigation cannot be taken against the petitioners.
Mr. Kaur has submitted elaborately that immediacy after death. So due to influx of time that this is
since 2007,
this has faded, it fades away.
Since 2007 we had been litigating, and the 2025 Supreme Court judgment says that the time period consumed in court is not.
That is in yes, in the recent judgment of Justice Datta.
Second Canara Bank.
Yes, second Canara Bank. There it has been considered. Those paragraphs were placed by Justice Mr. Kaur also. Yes. Yes.
That's 65.4 of that judgment. I have indicated it. What I have done, I have typed out their argument in black and our reply in blue. But I'll hand up. So that there is no further argument on facts. Now, Lord,
Anything that is troubling me that if the fresh scrutiny is done, it is to be done under on what basis?
Lord, what is that is
The fresh
indigency.
scrutiny has to be done.
Indigency. Not what. The honorable the division bench in 2024 said carry out the exercise. Once again, since substantial time has elapsed. Lord, we don't oppose this at all. Your Lordship has seen page 658 of the SLP, which is the union's letter welcoming the procedure to be followed. But can the company on its own whim do this? We wanted a safeguard to be, or say a safety valve for this purpose. Do this in presence. You would not be knowing who are the family members. Get it videographed if you so want. To what extent can we offer a transparency?
Now, if these 19 candidates did not submit their documents in support of their financial conditions, within which time they can submit?
7 days. Let them restart. We will do that. But we will free more time for that purpose. Then, Lord, 2006 policy was a nullity because that was not approved by the board.
Yes, that was the submission. Based on source of power which has been relied.
There was a delegation of power. Now, this is belied by page 95 of the counter and pages 58, 61 and 62 of the IA, which was the stand taken on in affidavit by the company. It says that this exercise was carried out with approval of board.
Where this approval of the board is?
Come to page 95 of the counter first.
Counter by union?
Counter before the Supreme Court. Yes, counter by the union.
Yes. Page 95.
95 first. Please come to 94, I'm sorry, page 94 first. Not the fifth line from the top of that page. There is total transparency in the acts and actions of the company. Has your Lordship found that? Page 94.
Yes, page 94.
1, 2, 3, 4.
The term casual employment, paragraph 5 probably.
Paragraph 4.
Paragraph.
Oh, achha, could be page 95 then in your Lordship's brief.
Which paragraph? Of
Paragraph
the
4.
supplementary
Paragraph
affidavit? Paragraph 4.
Of the counter. Page 94 or 95, maybe one page not there.
93.
93.
93, you are correct, 93. There is no irregularity and corruption.
Yes, there was no irregularity and corruption, and the allegation on his score is incorrect. There is total transparency in the acts and actions of the company. So far as the guidelines are concerned, the same are advisory in nature. The recruitment undertaken was against approved vacancies, and the same has been approved by the Board of Directors in its 266th meeting held on 14 September 2006. Now, this is after that settlement of 2006. Settlement took place in May 2006. The allegations made in paragraph 10 of the affidavit are incorrect. It is denied so and so. The governmental guidelines are advisory, and the whole position has to be viewed in the context of facts and circumstances of the case. The casual laborers are engaged in unskilled work similar to work of servicemen for designated employees who are in the permanent role of the company. The advertisements for the post of casual laborers in the company are for regular nature of work and not for casual nature. But has your Lordship ever heard of a situation where advertisement is issued for casual employment? The term casual employment was in use in the company, and all such persons employed on casual basis were being absorbed in the permanent role upon satisfactory completion of the tenure of casual employment. Recently, management has decided that the casual labor term or nomenclature will not be used for posts against permanent vacancies. Following this directive of the management, some of the casual laborers who had not completed the stipulated tenure of service had also been redesignated as servicemen 5. Oh, I'm sorry, 4. With reference to paragraph 11, it is stated that there was total transparency in the whole act and action approved by the Board of Directors. Nothing wrong has been done, and hence the question of fixing responsibility does not arise. So today to argue that we are trying to undo a wrong is something contrary to records. And therefore, the person who is taking this stand on affidavit should be hauled up.
Doing contempt proceedings lacking at
All these things were there. Perhaps should have been making the initiating the disciplinary actions.
That's right.
But also can you see the date of the affidavit
And the promotion order.
date of the affidavit? 96, 97. This should also be fine. 17 June 2010. And the disciplinary proceedings were initiated thereafter.
Advertisement of 2006-7.
What were there before the oral decision?
Yes.
That one-time dispensation your lordship has already taken note of.
Yes.
Then advertisement was for casual employment. This is belied by that sentence in page 94 and 95. Then about that settlement of 2006, it did not have the board approval. But CMD was present in the meeting. Please come to page 98 of the counter.
এক্সটেনশন লাগিয়ে ছবিটা দিয়ে পাঠিয়ে দেও একদম আনতে গেছে নাকি
Page 90.
Page 98 of that. I'm sorry.
Counter.
SLP was of the SLP. Of the SLP.
SLP.
Of the SLP. The subject issue of compassionate.
Yes, 2013 scheme, page 98.
Page 98 of the SLP.
Yes, page 98.
90.
Yes.
That's the settlement. Minutes of the meeting held on 24th March.
Yes, the 2006 scheme.
Yes. Now the argument is advanced that this did not have the sanction of the board. Therefore, it is an nullity.
Yes.
The subject issue of compassionate employment has been discussed between the management of GRSC and the union for quite some time. At the outset, the CMD informed that the company is working in a highly competitive environment wherein a number of private shipyards are prepared to undertake construction of warships and deliver them at a much lower cost and in shorter time frame. In order to do business against this competition, GRSC is required to maintain low cost of production, manpower cost being the major component of the ship's cost. Extreme control is required to be exercised to keep the manpower cost with the acceptable limits so as not to lose orders in favor of the private shipyards. However, in order to mitigate the hardships of the families of ex-GRE employees who have died in harness, the company is prepared to address the issue of compassionate employment to these dependents. In response to CMD's opening remarks, the union stated, deliberation where the CMD is present.
No, but the point was taken that there was no approval by the board.
Please come
CMD was not authorized.
Please come to page 6.
Based on the document of relating to delegation of power.
Please come to 699. Where is the requirement of approval? But I believe not, my learned friend will not dispute this factual proposition that the CMD has also been cautioned. But he has not been cautioned.
The delegation of power.
Please come to page 699,
yes.
Second volume. The body corporate, which is an 617 company, section 617 company, this is probably trying to escalate things to certain level, not as if it is. Please come to 699.
Schedule 1, 700. Power reserved for board of directors.
Now, please come to 699 first. What is this document?
Yes, yes.
This is addressed by the Under Secretary to the Government of India to the Chairman and Managing Director of 2004. I am
Yes.
directed to refer to your letter number so and to convey the approval of the competent authority for
Yes.
the proposed delegation of powers to the Board of Directors and CMD as under. 1. Powers reserved for the Board of Directors as per Schedule 1 attached with your letter mentioned above. So Board of Directors, Schedule 1. Constitution of and delegation of powers
Not required.
not
Two is
required.
not required.
3. Delegation of powers to the CMD as per Schedule 3.
Yeah, right. Then come to page,
Yes.
page 700.
Now please come to 700. What is Schedule 1?
Under clause 3, heading personnel.
Personnel. Powers reserved for the
Creation, appointment and promotion.
creation, appointment, promotion to posts in the ranks of general manager and above.
Yes, yes.
Termination of services, acceptance of resignations, including contractual bonds in regard to officers in the rank of general manager and above. Does not apply to workers.
Appointment. Promotion to the post in the rank of general
No,
manager.
creation, stroke, appointment, stroke, promotion to the posts in the rank of. So, appointment in the rank of, creation of the post of general manager, promotion to the post of general manager and above. Number what is Schedule 3? Please come to 702.
Clause 2.
Schedule 3 is
Appoint
not
and employ.
Schedule 3.
Yes. Schedule 3, clause 2 is
Yes.
relevant.
Please come to 703. To appoint and employ assistants, officers, servants, laborers, agents, brokers, contractors, and other workers for any of the purposes aforesaid at any remuneration, commission, or salary, and from time to time to dismiss, discharge, or retire such assistants, officers, servants, laborers, agents, brokers, contractors, and other workers, and to appoint and employ others in their places, subject to limitation hereinafter appearing in clause 26 hereunder. At the most
So
appointed.
therefore, according to it, it comes under the purview or power of authority of CMD. Come to page 700 again.
Yes. 705.
3. Personnel, heading personnel.
Personnel.
Yes. 700, clause 3.2, 3.1.
Yes.
Personnel policies relating to sanctions.
Sanction strength, service conditions, wages and salary, structures including pay scales and allowances, bonus, retirement benefits, welfare schemes, canteen subsidy, leave.
Personnel policies relating to sanctions.
Strength, yes, policies.
So to that extent, they are saying that the approval is required.
Policies for sanction strength. Not the, I have read that page 94 and 95. The board approved that.
Paragraph 4.
Paragraph 4.
So even if your submission is this is approval of board is sine qua non, in that event also page 93 comes in your aid.
And they have acted upon these.
Anything more, Mr. Majumdar?
Those citations, those judgments are cited. I just
yes.
personally, I need not trouble your lordship much with the detailed
yes.
facts of those judgments.
Policy decision you have submitted, then Tejpoka's case was also cited, that you have also relied upon. Then negative equality, you have made submissions, then debt in harness category, certain judgments were cited by Mr. Kaur.
Before coming to the judgments, please bear this in mind. This is a government company. Section 617 government company. As it then stood, the Companies Act 2013. Before 2013. But for central government employees, the DOPT guidelines apply. For government companies and CPSEs, the DPE guidelines apply. DPE has not framed any such policy for compassionate appointment for government companies. They seek recourse to the DOPT guidelines. And while opening my argument, I have shown to your lordship
does not apply.
The ministry had clarified that it does not apply to the autonomous bodies or the CPSEs. Number 2011 7 SCC 397. That was on the proposition that an illegality cannot be perpetuated. Paragraph 26 was the ratio of the judgment.
No, on the concept of illegality cannot be perpetrated to 2024 SCC online 3292 was relied upon by Mr. Kaur.
2024 SCC online. Yes, but I believe there are two judgments. 2020
Paragraph 9 to 15.
2024 SCC online 3292 and the other judgment was 2011 7 SCC 397. These two judgments.
Yes, yes, that was the first day. Yes, yes, 2011 7 SCC 397, right?
2011 7 SCC 397 was dealing with a question with regard to age relaxation, which was specifically prohibited in the policy of that particular organization. Casual laborers were disengaged and contractors were engaged. The laborers approached the CAT. Central Administrative Tribunal dismissed the application. A fresh recruitment process was initiated wherein they wanted a age relaxation. And there was specific provision that age relaxation would not be granted.
Based on which this,
Yes.
that is your sir.
Then the 2024 SCC online Supreme Court 3292. Now that was a case.
Yes. Which one you are now trying to distinguish?
2024 SCC online SC 3292.
Yes, yes,
A 3-judge bench judgment.
yes.
Now that was a case when the application for compassionate appointment was made 11 years after death till the son attained majority. In that context, not at first the employer had said, keep it in the register of compassionate appointment. Then ultimately he was rejected. So the employee's son came up with the stand that I have a legitimate expectation since you have put my name in the register.
Yes.
Then what comes 2023 14 SCC 376. This is on the proposition that there can
Policy
be
decision.
no negative equality or wrong.
No. No challenge to 2013 scheme by the petitioner, then it was a scope of interference as well as policy decision. In that context, this 2013-14
2023 14 SCC.
2023-14 SCC 376 was relied upon.
Yes, please come to paragraph 20 of that judgment. Now, this was a case where UGC pay scales were not being granted. Please come to that paragraph 1 first. The last 3 lines of page 377.
এই এটা একটু দাও তো, দেখবি জাজমেন্টের একটা আলাদা ইয়ে করা আছে, ফোল্ডার করেছিল আগের দিন, দেখো এখানে আছে, সাইট করেছিল একটা আলাদা নতুন ফোল্ডার, এখানে পাবে না, এখানে দেখো তাহলে বলবো এটা না, এটা একটু পুরোনোটা আলাদা সেট করেছিল। Just a minute. Twenty 14 SSC 376. State of Madhya Pradesh. Yes.
State of Madhya Pradesh versus Seema
Yes,
Sharma.
yes, yes.
Please come to that page 377, the last 3 lines of that page.
Page 377.
The first page of the judgment of the report.
Yes.
Writ petition number 14027 of 2010 filed by the respondent and it was allowed, and directing the appellants to grant the respondent writ petitioner the benefit of the UGC scale of pay from the date of her initial appointment.
Yes.
Paragraph 4. After completion of 8 years of service, the respondent writ petitioner claimed the UGC scale of pay as paid to the persons in the senior scale of librarian in colleges under the Higher Education Department as per the Madhya Pradesh Recruitment Rules 1990.
Yes.
The request of the writ petitioners for the higher pay scale, UGC pay scale, was not acceded to. The writ petitioner therefore filed the writ petition referred to above, which has been allowed, and the respondent writ petitioner has been directed to be paid the UGC scale of pay as paid to the librarians of colleges under the Higher Education Department. Next paragraph. In the High Court as also this court, the respondent writ petitioner contended that her service conditions were governed by the 1990 rules. The appellants contend that the 1990 rules were never applicable to the respondent. The 1990 rules were applicable to institutions under the Higher Education Department, the government Dhanvantari Ayurvedic College, where the respondent writ petitioner was appointed, was not under the Higher Education Department, but under the Ayush Department of the government of Madhya Pradesh. So it was a question of applicability of the UGC pay scales in that particular college, apropos the state rules of which were guiding that college teacher service conditions.
The fact situation was different.
Completely different. But 2021 5 SCC 638 was pressed into service.
Yes, 2021 5 SCC 638.
638.
Yes.
This was pressed into service in support of the proposition that policy is what is the scope of a writ code in interfering with policy decision. Paragraph 43.
Yes.
No quarrel with the proposition. Now still comes to paragraph 31. This was also a case of age relaxation not having been granted in view of existing rules. Please come to paragraph 31. At 654.
But this was cited in the context of whether challenge can be thrown to policy decision or not.
Still, not the lordship, the scope of writ jurisdiction in interfering with policy decision is well accepted. Not whether this will apply to the facts of our case. And this was a case of age relaxation being sought for.
Which paragraph you are?
Paragraph 31 at 654. While reverting to the facts of the instant case of the petitioners, what is prayed by them in the first blush appears to be attractive, but it lacks legal strength and foundation for various reasons. What are the reasons? The scheme of the 2020 rules, of which a detailed reference has been made, and rules 4 and 6 in particular clearly stipulate that the entry age to participate in this competition is 21 years and the exit age for general candidates is 32 years, and at least each candidate gets minimum 11 years to participate in the competitive examination, that is CAC in the instant case. For those who claim reservation vertical horizontal, they have numerous or unlimited chances and are also entitled for age relaxations. Thus, the scheme takes note in providing adequate opportunities to the candidates to participate in this competitive examination at all levels. It may further be noticed that under Rule 6 of the 2020 rules, there is a clear mandate that age limit prescribed in no case can be relaxed subject to the relaxations which have been enumerated for various categories. So there were statutory rules governing the field of examination. The only other point was rules of the game can be changed after it has commenced. But that phase Prakash has been placed into service. Your lordships will consider paragraph 65.4 of that judgment. It says that if the existing rules permit such change to be made, or if the advertisement permits such change to be made, then only it can be done.
But that is in the context of the appointment under open category.
Still then, not this will probably lead to various ramifications. Not suppose I have a rule. As an employer, I have a rule which permits that post commencement of the proceeding, I can alter the criteria. Then he can do so. In the advertisement, it has been mentioned that I can change this in the midstream. Then it can be done. Let's say not in that judicial service, it is depending on the number of applications, but quite often the cutoff mark is fixed, but that is notified by the PSC before the commencement of the examination. The bar is raised. Whoever who has attended this may be called for the next.
But in Tej Prakash, it has also been held that even after preparation of panel following the rule which was prevalent at the time of issuance of recruitment rules, recruitment procedure, but giving appointment is a separate thing.
Yes.
That depends upon suitability.
Of course. Then not that change of the game in the midstream.
How do you react to this after preparation of the frozen list on 31st of March 2006? That up to the third phase appointments were given, fourth phase appointments were not given for certain other reasons. So whether the second part of Tej Prakash comes in aid of the petitioner or in aid of the
paragraph 65.4 of the judgment. 65.4 is the crystallized answer.
Paragraph
65.4 of Tej Prakash. Now that's probably page 168 of my compilation. Running page would be 204. 65.2, I am sorry.
Yes, 65.2.
Page 204. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extant rules so permit, or the advertisement, which is not contrary to the extant rules, so permit. Even if such change is permissible under the extant rules or the advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. Please see, this comes under the heading of conclusions. Then the next paragraph. The decision in K. Manjushree lays down good law and is not in conflict with the decision in Subhash Chandra Marahwa. Deals with the right to be appointed from the select list, whereas K. Manjushree deals with the right to be placed in the select list. The two cases therefore deal with altogether different issues. Recruiting bodies subject to the extant rules may devise appropriate procedure for bringing the recruitment process to its logical end, provided the procedure so adopted is transparent, non-discriminatory, non-arbitrary, and has a rational nexus to the object sought to be achieved. Extant rules having statutory force are binding on the recruiting body, both in terms of procedure and eligibility. However, where the rules are non-existent or silent, administrative instructions may fill in the gaps. Placement in the select list gives no indivisible right to appointment. The state or its instrumentality for bona fide reasons may choose not to fill up the vacancies. Not that law was always there. But I have conducted a selection process. Suddenly the government has decided not to provide me the budgetary support. I can't appoint.
So even if this frozen list was prepared in 2006, ultimately, since there was certain complaints and it was found that there are certain bases, if authority decided that from the fourth phase onwards it will not be given effect to, then how do you react?
Not the case of the authorities that the 2006-7 vacancies notified are not being filled up. Objection is only with regard to identification of the persons who had been born in the list. Now, it is our endeavor to show that the stand taken was not intelligible. The person who objected has withdrawn his hands, leaving it to the good conscience of the employer, or not a procedure to be adopted. Not I demonstrate. Not today. I was in receipt of this amount of fund which enabled me to pay the salary.
But does it come within the periphery, whether this ratio of Tej Prakash comes within the periphery of appointment on compassionate ground? That the same thing I have also asked
This law has always been there. Not I can abandon a selection process provided there are intelligible grounds. But when called into question, you have to come up with justified reasons. This is not the reason cited.
So decision cannot be arbitrary. Starting from Sankarshan.
But these are my submission. But please permit me to hand up this.
Yes, yes.
Not the notes, but this is in reply argument.
Notes you have given at the.
But I'll give a one-page note in support of
Yes.
my submission. But this is the reply argument. I'm grateful to your lordships.
Issue. Mr. Somo Majumdar, senior advocate, Mr. Your name, Mr.
Singhania.
Yes, Mr. Singhania, learned advocate representing Central Vigilance Commission
Yes.
or the Union of India.
Yes. Vigilance Commission.
Central Vigilance
Number
Commission
3. This
has
one
made submissions. Mr. Majumdar, learned senior advocate representing petitioners, has given reply. Hearing is concluded, judgment reserved.
I'll hand up to your lordships.
Yes. Order file test একসঙ্গে থাকবে, এর উপরে থাকবে, এইটা দাও এর উপরে এই order এটা ওকে দিয়ে দাও।
Lord, we are really grateful to your lordship for a very patient hearing. I'm really grateful.
Now the most difficult task. Our burden is discharged almost.